to mention a matter, my lord, from the determination of the bench presided over by Justice Chakraborty. Because this matter was fixed for hearing, my lord, on 2nd April, that is tomorrow. So, Lord, I was just praying, Lord, let this matter come. There is grave urgency in the matter. Lord, a Thika controller, Lord, accepted a Form A from a petrol pump and permitted them to deposit, Lord, the Thika rents, Lord, with the controller. We challenged, Lord, the jurisdiction of the Thika controller before the tribunal. And, Lord, the tribunal has not passed any interim order. It was just, Lord, fixed for hearing on the 16th April. Now, my lord, there is some urgency in this matter. Your lordships may kindly, my lord, give some precedence. Lord, now, my lord, after Nimai Chandra Kumar, there is no dispute with regard to the jurisdiction. What is the jurisdiction of the Thika controller? Lord, a petrol pump which consists of pakka structures can't be, my lord, given liberty to deposit rent and after determination of a long-term lease.
After Chhana Rani's case?
Lord, now, my lord, the whole thing is crystallized.
Chhana Rani's case, what? Pakka and Kacha has gone.
No, not after Nimai Chand Kumar, it has been reinstated. The original my lord, special bench judgment has been reinstated.
Let us see. Of the Supreme Court I am talking about.
Supreme Court. I am also talking about Supreme Court.
Let us see.
Lord, may it appear tomorrow. Lord, upon notice I was mentioned. My
Lord. My lord, may I be permitted to, my lord, intimate your lordships, my lord. This is in respect of a pending custody application, my lord, where lordships are directed that paper books be prepared. It is already in the way, lordship, but in the meanwhile, lordship.
Then let it reach
my lord,
the destination.
Yes, my lord, the only difficulty, my lord,
it has not reached.
My lord, the only difficulty, lordship, my lord, it is my bounden duty to inform your lordships that, my lord, the minor daughter, she has decided to live with her father. So, my lord, we have already initiated, we have informed the mother, and my lord, she has not responded yet, my lord. So, my lord, she is presently in the custody of her father, my lord. This is all that we wanted to inform your lordships. Grateful, my lords.
My lord, may I be permitted to mention one matter from the determination of my lord Justice Tapobrata Chakraborty and Parthasarathi Chatterjee, my lord. The issue involved here is that the petitioner is a doctor. Now, my lord, he has been selected as a assistant professor in radiology in IIT Kharagpur. Now, my lord, the IIT Kharagpur is not allowing me to join over there in spite of the provisional no objection certificate issued by the state of West Bengal. Now, my lord, the issue is this, that they are saying that since the writ petition is pending, what would happen if you are not able to get a favorable order, my lord? May it appear tomorrow, my lord?
Let us see. We can't assure tomorrow.
My lord. Grateful lordships.
For non-prosecution, my lord.
Oh, always welcome.
Application.
Applications, give all the applications. Application relating to this determination, parent determination. Give order 41, rule 11.
Order 41,
order
rule
41, rule 11. Order 41, rule 11.
Order 41,
Don't need to mention, you give. I do not know. Give.
Well, it may be permitted, my lord, to mention this matter, my lord. Your lordship was pleased to, my lord, send this matter for mediation, my lord, on December 20th. Now, my lord, the mediation has been successful, my lord, and my lord, the matter can be disposed of. My lord, this is the partition suit, lordship. Great.
My lord, may I be permitted to mention, my lord, one application from the determination of the Honorable Justice Chakraborty, your lordship.
What?
My lord, the matter relates to my lord, family pension. Petitioner is more than 70 years old
This
lady.
is not an urgent matter. It can wait. When you have waited for such a long time, you can wait. If there is extreme urgency which cannot wait for fortnight, we can definitely take up all those matters. But these are the matters which are
more than 70 years old lady is not getting pay family. More than 70 years old lady, my lord.
So you can wait for 15 days more. No difficulty. Let's see.
May I have your lordship's kind indulgence to mention a matter for upgradation? Your lordship, in item number 107.
Every time the last week, the entire list was called, nobody responded.
Your lordship, we were there, we were present in the.
I do not know because the list was called, nothing. Just wait, no upgradation.
Your Lordship, may I be permitted to mention one matter? Your Lordship, this matter inadvertently is appearing under the heading hearing in monthly list of April, item number 166, but the matter should be under the heading application, Your Lordship.
We will hear out the hearing, the main matter will be with the application, don't worry. Yes.
But to mention one thing was determination of Justice Chakraborty, my lord. This is related to prevention of a former professor to the Jadavpur University, former vice chancellor of Kazi Nazrul University. His tenure was complete, and he wanted to join to his substantive post of professor of philosophy at Jadavpur University, but he was prevented from joining there for the last 10 months. And he is not getting any salary and others. So that is pending before, because there is no interim order. So there is no scope for hearing before just Honorable Justice Kaushik Chandra in near future also. But the point is that
Why Kaushik Chandra?
because it's group 2 matter. I don't know.
So what appeal? We are concerned with the determination of Justice Chakraborty.
At the group 2 matter, my lord. Education.
He has the
Yes,
determination.
yes.
What for?
Because my lord, because interim order for.
Interim order.
Because
We
why-
don't know. We don't know if I do, because associate professor.
Professor, not even
Now you are a professor.
No. He was professor for the last 15 years.
You say the tenure has been.
So his tenure as a vice chancellor was over.
Oh.
His tenure was vice chancellor over because the controversy was vice chancellor something is over, and because to settle that if tenure is over, he has no right to be there anymore. So on the ground that he requires a no objection certificate, then the scope for the no objection certificate for a person who is last is.
So
Here the
he is
panel-
in the same institution.
No. He was the vice chancellor for 2 terms at Kazi Nazrul
In the
University.
same institution or somewhere else?
Somewhere, Jadavpur University. He is a professor of Jadavpur University. Well, it is not.
You are having a lien there on your.
Yes. Because even they have no because most of the university don't have the basic concept what is lien constitute actually. Lien can't be granted. Lien is a substantive right of a person. Lien is substantive right.
Let us see.
Your Lordship, it's a matrimonial appeal, Your Lordship. I'm praying for inclusion, Your Lordship, for the first time, for admission, Your Lordship.
Matrimonial appeal does not require admission.
Hmm.
It's the first appeal.
Not one assigned matter, my lord, for year. Because my lord, for long time pending, my lord,
Assigned to this bench.
my lord, this was on 2nd May 2023. My lord has directed that this matter has come up as an assigned matter. And my lord, thereafter this matter was
দিয়ে দাও
one
দেখি
part.
দেখি দিয়ে দাও কি আছে অ্যাসাইন ম্যাটার আমাদের বেঞ্চে আছে কি না দেখে নাও yes
May I be permitted to mention one matter?
that's the decorum of the Calcutta High Court that the seniors
Lord,
yes
with your lordships, my lord's leave, my lord, that contempt matters, my lord, which your lordship passed an order on 8/2. The matter should come up and nothing has happened, my lord.
with whom
With my lord Justice Procedural Vishwas. Giving this with
let us
lordship,
see whether
kindly, Lord,
I do not know whether his lordship is sitting singly or with some other division
is
bench
sitting singly.
তো এই বিশ্বাস সাহেবের সঙ্গে কথা বলো
I'm grateful.
You have lordship kind leave to mention, my lord, this matter, my lord, for admission. For this
order 41
order for
you need not have to mention we said that you pass on the slips
Sir, may be permitted to mention this matter, my lord. The direction for filing paper books on 12th June of 2023, my lord. Till date, no paper book was filed, my lord.
এই লওয়াজিমা
With my lords, kindly may I be permitted to mention this matter to be listed under the heading to be mentioned, my lord, so that I can file my affidavit of undertaking, my lord. So, and I can withdraw the amount which has been directed by your lordship to withdraw from the Registrar General, my lord. To be mentioned.
My lord, I'm mentioning from the correction of my lord's order.
Our order
Lordship, praying for a leave to file an appeal, Lordship.
without certified
Without
copy.
the original certified copy.
When the order was passed?
Order was passed on 29th of February 2024. And we applied for it on 21st March 2024.
Oh, so long you waited.
Because Lordship, we were not added as a party respondent to the original.
Whatever you waited for such a long time, then you'll have to apply for certificate.
We did not know, Lordship, that the order was passed.
Whatever. You secure the certified copy and then file it. No. Virtually 1 month has gone.
I am for the
Cannot to be mentioned as
Lordship. This is Lordship. This is change brief, Lordship. Kindly see the last order. Lordship.
What change brief?
Lordship, sole appellant died. On the death of sole appellant, I filed an application for substitution after setting aside abatement and condonation of delay.
Sir, the appeal is already dismissed as abated.
Lordship, I also filed an application for recalling of the orders.
This can't be done.
Lordship, kindly hear me. Lordship, kindly
then why? It to be mentioned diye choke no?
Lordship, I mentioned this matter, Lordship. Lordship, fight between father and the sons. Lordship, some of the heirs are already on record in another capacity. Is there the
You'll have to take out an application. Yes.
Already applied. Already filed an
Please
application.
give the application. It will appear.
Yes,
in the
appearing.
application.
Appearing.
As an application, not as to be mentioned.
Already appeared.
Sorry, not appearing. The matter has wrongly been listed under the heading to be mentioned. Let this matter be listed under the heading application.
It was appearing.
This can't be a device to get your matter
Lordship, it was appearing as
edge over the other matters, sir. I remember to be mentioned something else was said to us. That's why we directed the matter to be listed as to be mentioned.
Your Lordship,
we will not permit the, I would say, the best engineering of the lawyers to get the matter over the other matters.
Your
Sorry.
Lordship, sir, graciously please to indulge me to.
Which one?
I mentioned this matter on the earlier occasion, Lordship.
Impeachment has already taken place. We have already said that they are dismissed as evicted. They have to take out an application for setting aside the eviction, which they have done. Now, to be mentioned, so that application has. That's why I said. This device to be. Why to be mentioned?
Lord, it was appearing as application, item number 331 in the list of most probably Thursday, on which I mentioned before your lawsuits, and then it is appearing today as to be mentioned.
Your Lordship, the matter is already fixed for hearing in the trial court on 16th of April. I am for the respondent number 1 to 4.
You are for?
I am for the appellant defendant of their suit.
Defendant in their suit?
In their suit. Two
Yes.
suits.
You have taken out an application under Order 39 Rule 4.
Yes.
So you wanted this application to be heard.
Yes, my lord.
So we can direct. Is already 16, so let him.
Because, my lord, on earlier two occasions, the learned judge didn't hear the matter.
We will direct this matter to be heard on 16 and to be disposed of within 1 week therefrom. Have you filed an objection to Order 39 Rule 1
Yes,
and 2?
my lord. Written objection has been already filed.
Order 39 Rule 1 and 2.
Yes, my lord.
You have filed also objection.
Yes, my lord.
Have you filed your, because it is a hearing, so you have filed your affidavit in 39(4) also.
Yes.
No, they haven't. They haven't. They haven't.
It's already been finalized. We will file it on.
I do not know why the matter is now listed for hearing.
Your Lordship, on one date, the learned.
Anyhow, what we are doing is, just when you have come, what we are doing is that they will file within the course of this week. Objection. You file if you want to file a rejoinder within a course of 3-4 days thereafter. Since the matter is already fixed, let injunction and 39 Rule 4 both be taken together and disposed of.
In the meantime, my lord, they are constructing the building very
That
rapid.
is why we asked.
Yes,
You are
my lord.
constructing.
Your Lordship, we are constructing the building under the order of the learned court.
Can a court substitute itself in the place of the executives?
Your Lordship, what has happened? Just
A recent judgment of the Supreme Court in 2024 volume 3 SCC. The Chief Justice of India has said that the court cannot substitute itself in the armchairs of the executives.
And my lord, they are.
Whether you have any sanction plan, you are making a construction. Do you have a sanction plan? Then how the court can say that you go on with the construction?
Your Lordship, what has happened? The former defendant in the title suit are the recorded owner of the suit.
True. There is no dispute. You may have a best of the title on the earth. But if you make a construction, you have to seek a permission either from a municipality, from a panchayat, from a municipal corporation. Have you got any permission?
No, Your Lordship.
Then how the court can permit you to go on with the construction? How? Whether the court has any authority to do so? I'm asking you very simple. You show me that you have a permission, no doubt. We are not going to interfere. Show us any permission under the law. Construction. Unknown in the legal parlance. The court is behaving like a municipal commissioner or a pradhan of the panchayat. Show us the permission, no difficulty, we will not interfere. He says that if the permission is granted, you know the law.
Yes, sir.
Without the permission, nobody would be allowed to make any construction. Show us.
Your Lordship, my humble submission is that matter is fixed on 16th.
Sorry, sir, you can't take. Then you don't make any construction till 16th. Or till the entire injunction application is decided. Don't make a construction. You don't have any permission. You don't have any sanction plan.
Verbally, the learned trial court also instructed them not to carry out the permission construction. But even after that direction, the construction is going on. Doubling the manpower day and night. And the power by which they are constructing, those persons are not the real owner of the property.
That is to be decided in the suit.
Yes, my lord.
The
Yes,
court
my
will
lord. Yes,
decide. We are not
yes.
going to make anything. They are in possession. They are continuing.
They are not in possession.
Sorry? Then how they are making construction?
We are in
In their document, they have.
Sir,
In their
when
document.
we are talking in your favor, then don't.
I'm not interfering. Your
You are alleging at one go, at one stage that they are making construction, and you say they are not in possession. Is it believable? A person who is not in possession, how can he make a construction at the property?
In their document, they have disclosed that they are.
That's the maybe, sir. The document would show something else, but from your stand, it appears that they are in possession and making construction.
Yes,
That's
yes,
all.
yes.
Don't make construction. Though the scope of the instant appeal is limited, as the trial court, while passing the impugned order, dated impugned order number 5 dated 15/3/2024, fixed the hearing of an application under Order 39 Rule 4 of the CPC. But according to the learned advocate for the appellate, they wanted an interim order to be passed, as the appellants are as the plaintiff respondents are continuing with the construction. Full stop. For the limited purpose, we directed the notice to be served upon the respondent, who is now represented before us. It is uniformly submitted by both the counsels that the hearing of an application filed under Order 39, Rule 4 of the Court of Procedural is fixed on 16th April 2024. However, the counsel for the appellant vehemently submits that, taking advantage of the order, ad interim order, the plaintiff respondents are banking upon to continue with the construction, and in fact have doubled the manpowers, so that by the time the injunction application or an application for vacating the ad interim order of injunction is decided, the situation would become irreversible. We asked the counsel for the respondent as to whether there is any permission or a sanction obtained from a competent authority for construction at the site. The counsel for the respondent, in his fairness, submits that the constructions are being continued under the yes. Under umbrella of under the umbrella of the order of the court. Stop. In such view of the matter, when we find there is a dispute as to the title in respect of a property, any constructions made thereupon, may create an impeachment of the right if ultimately decided in favor of the party. In such view of the matter, without interfering with the impugned order, we direct that the plaintiff respondent shall not continue with the construction already undertaken until the disposal of an application for temporary injunction, as well as an application under Order 39, Rule 4 of the court. Since the next date is fixed for hearing of an application under Order 39, Rule 4 of the court, we have been given to understand that the pleadings to an application for temporary injunction is complete in all respect. We thus do not find any impediment on the part of the court to decide both the applications, namely application under Order 39, Rule 1 and 2, and an application under Order 39, Rule 4 of the court's procedure together. So, since the plaintiff respondent has not filed the written objection to an application under Order 39, Rule 4 of the court, which according to the petitioner, which according to the plaintiff respondent is otherwise ready, we therefore permit the plaintiff respondent to file written objection to an application under Order 39, Rule 4 of the court in course of this week. Rejoinder, if any, shall be filed within 4 days from the date of the service of the service of the copy of the written objection. We direct the trial court to take up both the application for temporary injunction and an application for vacating the ad interim order of injunction together on the next date so fixed, that is 16/4/2024. The trial court shall not grant adjournments to either of the parties unless necessitated by unavoidable and unforeseen circumstances. Even in this regard, the endeavor shall be shown by the trial court to dispose of the aforesaid applications within fortnight from the said date by passing a reasoned order in accordance with law. Nothing observed herein shall have any persuasive impact on the decision to be taken on the aforesaid applications by the trial, decisions to be taken on the aforesaid applications, and the trial court shall be free to decide the same in accordance with law.
May create for a direction upon the local police to see that no construction is further.
Sir, when he is there and the injunction is passed in his presence, I believe that the
Whether his
litigant
client will abide by his
will
direction
respect.
or
If
not.
it is not, then you have a remedy.
Much obliged.
What is extension? Appeal admitted?
I am for the petition.
No, appeal is admitted.
Yes, admitted and an injunction order was passed.
When?
Uh,
Oh,
Initial order was passed on 9th of October 2020.
I have passed. Create a third party interest and also from it. Yes. When both of you are ready, we can.
Alert.
When both of you are ready for the main matter.
My lord, any day. I am appearing for the respondent number 6 only.
6. Plaintiff?
Respondent.
You are a plaintiff respondent or
I am the
you are a plaintiff
petitioner. And I
number 6. Who are you? The promoter?
Promoter, my lord.
and I have sent the copy of the respondent number 1 to 5, but that has been written answered on the with postal remark that door intimation sir, but
Who are they? 1 to 5?
Original owner.
Owners.
Owner.
So the developer has come because it has been interested.
My lord can keep it on any day.
You can also appear for them as well.
My lord, for that I have
One
to
is
take
an alter ego. You are, sir, you are taking all the, I would say, steps on their behalf. So,
My lord, for that I have to take instructions.
they are the owner. Trusted. So he's the main person.
My lord, I appreciate what is falling from your lordship, but I have to take instructions for that.
How the postal articles have come? Served?
With the respondent number 1 to 5, the postal instrument is door closed, intimation is given.
Oh, intimation given. So not claimed.
Not claimed.
Not intimation given.
For respondent number 1 to 5, and 6 has appeared.
The matter is listed for extension of interim order. The affidavit of service filed today reveals that the service has been effected upon the respondents. Stop. The respondent number 6 has entered appearance. The respondent number 6 is a developer in respect of the property in question on the basis of the agreement entered into by and between him and the other owners, namely the respondent number 125. There is no appearance on behalf of the respondent number 125, despite the service effected upon them. In such view of the matter, let the appeal and application be listed. We are fixing on 17th April.
My lord.
On 17th April. The interim order granted earlier shall continue till the end of the month of April 2024 or until further order reaches. Yes.
Grateful. For the respondents.
Yes.
But I appear for all the respondents.
I am for the petitioner, my lord, led by Mr. Bhavani Prasad Mondal, my lord. Earlier, my lord, granted interim order.
But I'll
Therefore, extension of interim order, my lord.
But
and
this
fixed
was
another
listed
date.
on 21st.
Yes,
21st, it was not
But your
listed.
lordship can dispose of the appeal. Lord, this is a partition suit. Injunction was refused. Your lordship passed an order of injunction. Kindly restrain both the parties and direct me the suit to be over within a particular period.
Written statements are filed by all the parties.
Written statement, written objection file করে জমা দিতে written statement তুমি file করেছো. Yes. Yes, my lord. It was not for framing of issue and discovery inspection. The impugned order says.
And what was the interim order granted by us?
An injunction was paid for by the plaintiff. I am the defendant.
Yes.
No, what is the interim order?
Your lordship
From changing the nature for a period of 8 weeks. So that's the only.
But even for the plaintiff, Lord, my instruction is, Lord, I'll show the photographs. Lord, they are on the garb of Lord injuncting me. They are trying to change the nature and character by putting Lord
both of them.
Yes.
Both, Lord, both. Yes.
By consent of the council appearing before us, the appeal and applications are taken up together. The instant appeal arises from an order by which an application for temporary injunction was rejected by the trial court. At the time of an admission of the instant appeal, this court passed an interim order restraining the defendant / respondents number 1, 2, 3 from changing the nature and character of the suit premises for a limited period. The aforesaid ad interim order was passed on 19/1/2024. and the matter is and the matter is listed today for extension of the interim order. Both the counsels for the parties submits that since it is a partition suit, any changes that would be brought thereat may have some cascading effect at the time of the passing the final decree. The counsel for the senior counsel appearing for the respondent submits that although they have been restrained from changing the nature and character of the suit premises, but taking advantage of the same, the plaintiff appellant is also trying to change the nature and character. Full stop. In such view of the matter, and bearing in mind the nature of the suit, which is primarily a partition of the undivided property, we therefore feel that the ad interim order of injunction is modified to the extent that the parties to the suits shall be restrained from changing the nature and character of the suit premises. Full stop. Since the suit is otherwise ready for hearing, as the date is fixed for framing of the issues.
Already framing of written statement was filed last year in 29th April.
Framing of the issues means written statement is already there.
And I think, Lord, by now, Lord, the
we expect that. Now we feel that there is no that it would not cause prejudice to either of the parties. That it would not cause any prejudice to the parties if the ad interim order of injunction passed in the instant appeal is allowed to continue till the disposal of the suit. Accordingly, the ad interim order granted on 19/1/2024 is made absolute to continue till the disposal of the suit. Stop. The trial court is requested to make efforts to dispose of the partition suit as expeditiously as possible, preferably within 8 months from the date of the communication of this order. Because the preliminary decree, then the final decree, there are many things. So 4 months, 3 months, it will not.
But only one thing, your lordship has made, Lord, the 19th January absolute. That was injuncting my clients only, Lord, and not to change the nature and character by Lord,
no,
as
we
well
have
as
said
by
modified.
your lordships have
Made
modified.
absolute with the above modifications.
Lordship, I'm grateful.
That we have already said. All disposed.
Grateful.
Yes, my lord. I am for the, my lord, appellant respondent, my lord. I am for the appellant respondent in the writ petition, my lord.
I am for the writ petition respondent.
My lord, by an order dated, my lord, 1st of March 2023, although, my lord, an order was passed, my lord, injunction, but however, formally the Section 5 application, my lord, was not, my lord, allowed. My lord, so kindly refer to, my lord, 1st March order, my lord. Considering
How the interim order is granted.
My lord, considering the peculiar circumstances, it was
granted.
It was granted because, my lord, if my lord goes to the interim impugned order, my lord, it is, my lord, completely, my lord, establishing a civil right by the police.
No, then how?
My lord, kindly have a look to, my lord, order dated 1st March 2024. Although, my lord, on that day, my lord, they said, my lord, they will file opposition, but in the written objection, they have filed altogether in the, my lord, application for stay and also
They will continue.
court has, my lord,
Connected applications.
my lord, they have used and, my lord, written objection, my lord, against the application for condonation of delay and also to the application for stay. My lord, I find, my lord, with my, my lord, limited knowledge, my lord, I find in the written objection, my lord, there was no point, my lord, taken against the condonation of delay. Because, my lord, on, my lord, 19th of December, my lord, stay application. My lord, the order was passed, my lord, the order impugned was passed behind our back, my lord. What is the order? ওগুলো সরি না অর্ডার গুলো না Yes, and my lord, kindly come to the impugned order, my lord.
30th of March.
Yes. Yes.
2023.
Yes.
We have gone through.
Yes, my lord. First of all, my lord, in the writ petition, they say, my lord, the lady said, the writ petitioner say, my lord, she is the.
Who are you? You are the. Who are you in the writ petition?
I am the private respondents.
Private respondent.
Behind our back, my lord, this order was passed.
Whatever.
Yes, my lord.
You were served with the notice. You did not appear behind your.
My lord, so far my instruction, my lord.
Instructions are always like that, but the documents would reveal something else.
My lord, kindly, my lord.
Whatever.
Yes, my lord.
Then.
My lord, in the writ petition, my lord, they pray their civil right to be protected yet to be decided, to be enforced by the police.
The suit was dismissed. The appeal was dismissed.
That again, the suit was for, my lord, this was not suit, this was application for preemption. Preemption
Under section
8 of the Land Forms Act.
Yes.
Trial court dismissed.
So who filed the application?
We.
As a co-sharer, which is adjoining owner or
as co-sharer.
As co-sharer.
Co-sharer. As co-sharer. My lord,
it was dismissed.
trial court dismissed. Trial court dismissed.
Dismissed on the ground of limitation.
No.
Then?
Trial court dismissed on the ground that entire share has been my lord, transferred.
Oh.
Thereafter, the appeal court hold that yes, we are the co-sharer within limitation. Preemption application is maintainable, but following the judgment of my lord Barasat Eye Hospital, my lord, the appeal got dismissed. But the
obviously,
court, yes, certainly, my lord.
You did not deposit.
My lord, the difficulty is
this.
My lord knows the difficulty.
No
there
difficulty.
There are several judgments of our High Court saying that
no. Then ultimately, the Supreme Court judgment is binding on.
My lord, this application, preemption application, was filed much prior.
So what?
My lord.
So what? The language. That's an interpretation.
But however,
does not say
yes,
that.
however, yes, that is the law. Yes, no, that is the law. But we against that we have preferred a civil revisional application. Initially, an interim order was there, and that application was served to them. They have accepted the notice.
After all, this has become now it is rejected. Your preemption goes.
At this stage, my lord.
At this stage, the fact remains that your preemption goes.
My lord, the civil revisional application is still pending, my lords.
Nobody
knows, my lord, nobody knows what the law will.
Know the law.
My lord, no.
After Barasat.
Yes, my lord, absolutely.
After Barasat judgment, anything
my lord,
more can be said.
My lord, nobody knows what will be the afterwards, my lord, after Barasat. Because, my lord, the preemption is such a subject, my lord, knows, my lord, much better than everybody. That, my lord, regarding co-sharership, the several judgments are there. Regarding entire share, judgments are coming. My lord, so each and every moment, my lord, situation is changing. So nobody.
I have taken a dissenting view in Seema Begum. In some of the judgments, I have taken that entire share, half share. I have said nothing. The judgment of
Chhana Devi.
Not Chhana Devi. The judgment of the single bench is not a correct proposition of law.
That refer to the larger bench.
That the later on referred, it was held that yes.
Yes, that has been also considered by the.
My view was accepted.
Also considered by the Honorable Supreme Court.
But after Barasat,
my lord, nobody knows, my lord. Nobody knows.
Barasat, what remained?
Because, my lord,
nobody deposits the entire consideration amount shown in the deed.
My lord, because of
After
the
that,
previous judgments of our High Court.
Whatever, my judgment is also there. But after all, Article 141.
Yes, absolutely true.
Of the
But
that law declared by the Supreme Court is binding on all High Court.
But at this stage, my lord, the Barasat.
After Barasat,
after Bharat highest court judgment, my lord justice supersedes what is passed at a judgment. My lord distinguishing that it is not applicable to the West Bengal. But that was also set aside by the Supreme Court ultimately. After
That was not set aside. That has been, my lord, in subsequent judgment. Abdul Mokim.
No, I am out of touch for a pretty long time. Anyhow,
in Abdul Mokim's case, my lord, it has been considered, but my lord, no, my lord, in this field, my lord, yes, my lord. So far, my lord, relates to the police protection. দলিলের কোথায় রেজিস্ট্রি অফিসে কোথায় দলিলের ক টাকা দিয়েছে তো দলিলের ক টাকা দিয়েছে 6 টাকা দিয়েছে জীবনে কিন্তু কথা বলতেছে দলিলটা দেখো দলিলটা আলাদা আছে মনে হয় পিটিশন আছে ফাইলের মধ্যে আছে চাষি যেটা রেজিস্ট্রি করেছে my consideration that is that কিচ্ছু বলে কথা বলছি অনেক আসি না বললো আপনি ডিস্ট্রিবিউটর টাকা দিন Register officer, register of the class letter. And my lord, Lord, বলছি পাঁচ দিন ধরে
কনস্ট্রাকশন করতে পারছি না
my lord, irrespective, my lord, in civil revision application, my lord, irrespective of the valuation, my lord, because the deed does not carry, my lord, any memorandum of, my lord, schedule of memorandum, schedule of payment of money, and it says, my lord, the deed value only. What is the transaction value? That was not
in the recitals, in the contents.
No.
Is it?
No,
Impossible.
nothing.
Impossible.
Nothing. My lord, kindly have a look to the deed.
At a consideration of rupees such and such, it is not indicated. What are you talking? Sale deed will not contain the consideration price.
Only said, my lord, in the top, my lord,
It is not. Inside.
Kindly have a look. My lord, may I read for my lord? It is in Bengali, so I can, my lord, able to, my lord. আপনি বাজার দর যাচাই পূর্বক
give us
yes my lord I have indicated in
you did not let me see first.
There is no my lord memo of my lord
or it is not in the Bengali deed, it is not.
Taka jai is required.
That is in the English form.
That is memorandum consideration of memo. My lord, kindly see. I have indicated.
Ashok Kumar Doloi is a Creta, is a purchaser, and the Creta is Roti Khan Doloi.
appropriate market value.
Just wait.
Yes.
কোনো পশুর সম্পত্তি ক্রয় এইভাবে সংস্কার নেওয়ার জন্য অন্য কোনো সুগ্রহ করিতে না পারা যায় that's a legal necessity that I need it. বর্ণিত সম্পত্তি বিক্রয় করিবার কথা ঘোষণা করিলেন declared that he wanted to sell. or আপনি বিশ্বস্ত
Government valuation is 80,000.
from a
What was the transaction that is not there? Page কত এটা আমাদের আছে
you have agreed, you have shown your intention to purchase. আপনি বাজার দর 10% যাচাই পূর্বক বর্তমান সময়ে উচিত মূল্যের দ্বারা ক্রয় করিতে
No amount was written.
if you intend to purchase at the market price, then আমরা আপনার সম্পত্তি লইয়া সহিত আলাপ আলোচনা করিয়া ভিন্ন সম্পত্তি শুদ্ধ পরিবর্তনে বিক্রয় করিয়া দিলাম. Then we consulted everybody, we took the advice of many people, and now we sold it. So বাজার দর নিম্ন তহসিলের
And my lord, another thing, my lord, yes, boundary is also disputed. We have taken all the my lord points in the my lord plan, and that has to be yet to be decided by the my lord civil revision.
You are a co-sharer, the boundary is disputed.
Yeah, the boundary mentioned in their deed, on the ground of co-sharer.
It is a undivided.
Yes, undivided.
Boundary.
Yes.
What are you talking about?
That is true. And the government valuation, my lord.
Just
yes.
This is what I am নগদে বুঝিয়া পাইলাম Hon'ble means I think
কিনেছে কত 60 ঠিক আছে থাক না
বিক্রয় কবলা অশোকের কথা पॉइंट बीच में डाला है ना इसमें पॉइंट के पास तो पैसा भी चला था कि बीच में 2 कार्ड भी तो 8,000 इसलिए मैं थोड़ा
And what at the same time, my lord, government valuation shows, my lord, 54,000. At the same time.
Oh, it is a 8,000 or 8 lakhs?
80,000.
80,000.
80,000.
80,000.
Comma is what?
Not comma, is the full stop. That is what I am thinking.
Yes.
But one zero is missing.
কি আছে দলিলটা দেখি No, what? There are some dispute with regards.
One matter is another matter.
What?
I'm on the state, my lord. I have nothing to do. My lord, clear is there.
You will record that you have nothing to say in this matter.
Yes, my lord. Only to comply with the order passed by the honorable single bench. My lord, that is why we complied with the order. And also,
deed is is a reflective of the situation, that it says the Bajar Mulle, and the Bajar Mull has been reflected in the first page.
Dolil Mullo.
No, Bajar Mulle. Correct.
Dolil Mullo.
Sorry. Dolil Mullo no.
Mullo Mong.
First
page, my lord.
No, I'm talking about the second page.
Second page.
আপনি বাজার দর যাচাই পূর্বক বর্তমান সময়ে উচিত মূল্য দ্বারা ক্রয় করিতে চাইলে দেন আমার আপনার সম্পত্তি লইয়ার আত্মীয় পরিজনদের সহিত আলাপ আলোচনা করিয়া নিম্ন তফসিল বর্ণিত ভূমি চিরতরে
দখল ছাড়িয়া yes, my lord,
নিখুঁত
this
তারপর পূর্ণস্থাতে বিক্রয় করিয়া দিলাম। That is what it says.
my lord, irrespective of the valuation,
বাজার দর which is 80,000.
80,000 as they
So-
say, my lord. My lord,
So-
irrespective of that, my lord,
How much you deposited?
54,000 plus
54.
10%. Market value. This is the government value. Government value as per on that date. My lord, these are the things. my lord.
After Barasat, nothing.
But this was transaction before Barasa. My lord, these things are to be decided by the my lord, civil revisional court. My lord, I
Not going to this.
my lord, my lord,
Not-
only thing, my lord, whether the order impugned is sustainable in the eye of law or not. Because even a co-sharer right cannot be, my lord, by way of order passed in a writ petition directing the police to have a picket and my lord, to raise a construction, that is amounts to partition. How far the my lord writ court can pass this order? Because in the plaint, my lord, we have
That is true.
my lord, we have taken my lord specific plea that the property is undivided. Execution. Execution কেন হবে? আমার তো শুধু dismiss হয়েছে। It's not. দেখি এখানে জাজমেন্টটা দেখ মুরলী বাবা।
Yes, and when you support this order.
And my lord, on this point, my lord, I would rely a judgment of our honorable Supreme Court that my lord, that Muralidharan's case, my lord.
That?
My lord, P.R. Muralidharan's case, my lord, knows, my lord, it is 2006 4 SCC 50.
What?
The writ court cannot, my lord.
That is what is there.
Yes.
Give it.
বই বলবেন।
Just 1 minute.
My lord, it says, my lord,
I'm coming. Sir. I'm coming. Don't worry.
kindly come to last 2 pages, my lord.
First thing is,
Yes.
you have purchased a share in a plot of land. He's a co-sharer. You have purchased from a co-sharer. Now, co-sharer, whether a co-sharer of the property can sell the property with demarcation. Let me learn the law first. Can he?
My lord, may I just, my lord, what is happening in this matter? After dismissal of the, my lord, 2 application for preemption, my lord, and my lord, or kindly come to the order of the revisional application. Revisional application was stayed, not pass an order, interim order, not to alienate or transfer the property for a period of 6 months. That was left long ago, 1.5 years back.
We are not concerned. We are concerned with the impugned order, sir.
My lord,
Now let us forget the preemption application dismissed on that technical ground that they did not deposit the entire constitution money. Matter is pending. Forget about it. Let us see they have not applied for preemption. Let us go to that.
Yes.
They have not applied for preemption. Whether such an order can be passed by a writ court. I am asking you.
Kindly consider the background of the case. This person, my lord, kindly see this photograph. I am making construction. This is my.
It's a agricultural land or a vastu land?
As per record, Doba.
Doba.
As per record, Doba, not only that, they say, my lord, Indira Awas Yojana, they granted loan. They taken loan. My lord, Indira Awas Yojana, my lord, discontinued, my lord, long ago. And my lord, no
homestead land. My lord, I am showing no loss.
in their written objection, my lord, they have, my lord, they have submitted the, my lord, record of right.
First of all, my lord,
Therefore,
is it a Doba?
Yes.
homestead land. This is the
Page 11 of their
Doba means the
water body.
Water body.
As per record.
Yes, then how you are living there?
We are not living. They are claiming to raise a construction.
You are
Co-sharer.
No, you are doing any cultivation there?
No.
You can't do it. Are you doing any pisciculture?
My lord, page 11, kindly have a look to the, my lord, their written objection. They rely on a, my lord, the record of right. They rely. It says Doba.
Kala and Vasco homestead.
Even without any conversion, my lord, there are many things to be decided.
Conversation was
My lord, and not only that, even I assume that it is Bastu, even I assume that it is Bastu. Still, I am a co-sharer. If my lord preemption, my lord has correctly pointed out, my lord, I am deeply obliged. My lord, kindly,
not really. Because my lord, kindly see my
whether the writ court
kindly
can pass
see
this
my-
order.
my house.
Sir, you are making a construction. If he says that it is partly Kala, partly Doba,
Yes.
means the
It is
partly
there
home
for
is partly Bastu, partly there is a water body. If you make a construction in the best portion of the
Yes.
property, whether that is permissible as a co-sharer,
My lord,
you
I
will not
cannot-
claim any equity.
with regard to my
What?
lord, I will not pay for any equity with regard to my construction. But
How can you?
kindly, my lord, kindly appreciate the background of the case. Kindly appreciate. My lord, this husband, my lord, was a 95% handicap person. So the government considering his actual.
Everything we can extend sympathy to you.
Yes.
We can extend, but we cannot ignore the law. If there are 4 co-sharer in the property, one of the co-sharer who is a 95% handicapped, he has been extended certain benefits of the schemes floated by the government. Does it mean that the rights of the other co-sharers are overridden?
Possession, since there is no suit for partition filed by them.
Not necessary, sir. You are.
I am existing in possession.
Sir, that's why I say civil concept is a different, emotional and sentimental concept is something else. Even a co-sharer is not in physical possession.
Yes.
But his possession is through the other co-sharer.
Other co-sharer.
The other that's a very golden and fundamental principles of the co-partnery property.
19.
Fundamental and very, I would say, the broader question. You are occupying in commensurate with your share, means your vendor, they were occupying, and on their behalf as well. Unless they claim an ouster. How can they claim an ouster? They have to go and seek that I have acquired exclusive right. By ousting them, they have no right by way of an adverse position. That was not done. Then, partition suit, there is no limitation. Parties may not choose to get it partition because it has a brighter side as it has a more darker side as well. They may not choose. That does not mean that the right is evaporated.
No, I am not saying that right is not evaporated.
You said that you did not file a partition suit. Not necessary. Why not necessary?
Kindly appreciate, my lord.
How you can be permitted to make a construction and that too without the concurrence of the co-sharers?
My lord, my lord, kindly appreciate one first thing, my lord. There is a government it was allocated the grant fee for construction with regard to my existing possession where I am at, where I am my residential property, structured house is there. My lord, this is the government scheme and my lord, government was acted.
Government takes a decision, deholds the statutory provision. I am asking you. If the government has taken a decision, deholds the statutory provision.
With regard to my possession, they have consented my possession, my lord.
Where is
My lord,
your position is not exclusive.
But my lord, that was consented.
Sir, you are a stranger purchaser, sir. Your position is not higher in degree than them.
Kindly see the impugn order once.
Sorry, you can't.
My lord,
And are you aware of section 14 of the West Bengal Land?
Yes.
Sir, your lordship kindly come to
How can this order be passed?
kindly come to the impugn order. Kindly come to the impugn order.
That is what I wanted you to come.
Kindly see my lord impugn order.
Tell us and justify. Read slowly and justify each sentences. Read. Justify.
The complaint is that while she was effective construction, because I have got ongoing construction. And two of them are government allotted to me. It is not that I am not doing construction. The construction is going on her property. With the loan from the
Now question is her property. Will you justify her property? I am again asking, do you justify her property because you are a co-sharer? It's the property of all the co-sharers.
But I have every right to the property.
Each and every, yes.
Every
inch.
Not each, even I am going into a molecule of the.
But
Yes.
case in the distribution as well, mandamus appeal.
Not even an atom. It goes
But
for.
this is case in the mandamus appeal also. This is one of the ground for this mandamus appeal. Your lordship.
What?
That since they are supposed to have right and.
What are you talking? They are claiming
No,
as
there
a
is
co-sharer.
no such ground to that extent. The mandamus appeal also.
They have stated in the petition that.
In the,
they
my
are
lord,
co-sharer.
kindly have a look to page 59. Page 59 of the, yes, page 59. Can to stay application page 59, my lord. Stay application page 59. Stay application. Memo tablet. Memo tablet. Page 59 specifically, my lord, in the plaint, my lord, you have said, প্রকাশ থাকে নালিশি দাগে ভূমি এতবৎ partition হয় নাই.
It's not that.
Yes.
Sir, I have read paragraph 4.
Yes.
Of the stay application, you have accepted.
Yes, my lord.
That originally the property belonged to the father of the petitioner, that is a.
Never took possession.
And after his death, it has devolved upon all the heirs.
Yes.
Yes, that's so.
And also, my lord said, my lord disputed their possession also.
We are not talking about position.
Yes.
We are not.
No, because, my lord, yes, my lord.
What more?
That was ultimately dismissed and confirmed by the appeal court. Now I am talking about to mandamus only 20.
I am again saying, sir, forget about preemption. Let us see, there was no preemption application filed by them. Let us take this situation. There is no preemption. In a court passage.
With due respect,
I am asking you, tell me, can a court
with due
pass?
respect, I have a that is not as a court to that, but since this is not the ground, but
I was there for nearly 19 and a half years.
but today,
Put a cap or a hat,
this is not the one.
which would fitting to the.
But kindly accident.
I have a judgment. Will not do. What is that judgment? What has been held? Tell us. We are condoning the delay and.
They have not challenged the order, my lord. They have not challenged the order.
We are extending the interim order eternally. Not to make any consumption.
I have no difficulty.
Let him come with the judgment. Let us see with judgment. Let us see.
On which backdrop the original order was passed? On which backdrop
I am appreciating every fact. I am telling you have purchased a share from a co-sharer in respect of a property. The deed cannot be impeached. The deed is the formal document of title, no dispute. The moment you acquired a title from the co-sharer, you become a co-sharer of the other co-sharer. No dispute. Let us now, please. The position means what? Let us see that you have been put in possession of the entire property. Let us proceed to that extreme case. More better than your case. You have been put in possession of the entire larger. Though you have purchased a share from a portion. Let us see. Still, even if they did not apply, they did not oppose your possession. Instruction detrimental to their interest in respect of.
I am not clear for any
equity when? Equity when? The difficulty is this. That if you improve the best portion of the properties, then the equity, very difficult to crumble it down. Then I'm reminding you of a 1993 Supreme Court judgment, 3 judgments in Daulat Ram's case. That the position at the time when the final decree is passed become irreversible. What, crumble down? Crumble down.
only 1 lakh 50,000 government and.
We will record that.
And my lord,
We will
they go,
record
and in this fashion,
and approach the government who has given a grant that this is what has
yes,
happened.
yes,
So he
government money, my lord,
recognize the money and thereafter he will diminish that money or.
government money, how the government money can be, my lord, expended in such a fashion? It is public money after all, and not only that, they are not living. They are not living in there. They are not living in there.
Our senior on the very first day.
Yes, when the judges are, when the judge, yes, sir. When
it may be a boomerang.
yes, sir.
Kindly appreciate how can a human being can stay in this house in a rainy season? Kindly appreciate.
And let us see. I am raising a question. When a question of law is pitted against the sympathy, empathy, compassion, which will prevail? No, answer me. Which will prevail, sir? I am asking you.
At the end of the question of law is will prevail. But it is undoubted. But whether your lordship kindly take, whether your lordship kindly go with regard to their mandamus appeal, which count they have mentioned, but there is no such count to the extent. This is the application.
What is the ground? They have said that they are the co-sharer. They have stated. Now the question is, if they are a co-sharer, whether it can be permitted to utilize the best portion of the property. That's the only question.
Further issue is whether you have any right to police assistance in constructing a house.
Because it is a government scheme. Government is awarded the scheme for.
That is how that right is enforceable by issuance of a writ. That is the issue we are trying to ascertain from you. Any individual, does he have a right to police assistance in constructing a house as against someone else, which can be enforced by issuance of a writ? That is a short question. No.
I come back to the exception because I am considered, I have totally on the basis of their ground, which they are treated in their memorandum of appeals. I am not.
Section 20 application.
Question, sir, which falls from the standard of the parties.
এটা না,
Will not
এটা কন্টেম্পটের অর্ডারটা কোথায়?
From
কন্টেম্পটের অর্ডারটা কোথায়?
I also
রিটেন অবজেকশন আছে, কন্টেম্পটের রিটেন অবজেকশনটা যে কন্টেম্পটের অর্ডারটা বের কর।
government scheme and there is a charge sheet. They have been
Yes.
They have been threatened.
Yes.
They have been this person was charge sheeted by them.
Yes.
Police have been charge sheeted.
We are all.
And when we background the government of the police
কন্টেম্পটের অর্ডারটা বের কর।
all the materials of
কন্টেম্পট আছে তো লেখা মাথা থেকে।
with regard to by the applicant, they have been charged sheeted.
Sir, we are asking you a very basic question. Forget about their application or no application. Say they have not made any application. Under which provision you have right to police protection while constructing your house? If somebody is creating a disturbance, there is a separate remedy. How, under which provision such a right is enforced by issuance of a writ, that the police should be there to see that you are constructing your house?
On the basis of the actual position of the area. Now you also kindly before you also positive order, but I shall use the epidemic with regard to condemnation of delay. You also kindly take
Already, my lord, they have filed, my lord. Yes.
Yes, I am filing affidavit in opposition. Appeal including.
My lord, kindly take up their written objection, para 1. They say, para 2. I am filing this affidavit in opposition against the appeal, including connected application. No, what, my lord, they are saying, my lord, my lord.
What is the cost title? The reference of the case?
Murali.
At the top of the cost title. Of that opposition.
Yes.
What is the cost title of the opposition?
Written objection.
Just Costa kill.
Rabindranath Dolai and others.
No. Case numbers. What has been given?
1 and 2.
Is what I want.
Yes, yes, 1 and 2. In the body.
Very-
Grateful to my lord. Grateful. Even in the body, they have specifically mentioned.
Even I am not admitted, but you will also kindly consider their application for section 5. Kindly consider. Kindly come to the section 5 application. You also kindly check the section 5 application on. What is the ground for condemnation of delay? Everything can be overruled on a day. Everything can be overruled since the law does not permit any person, any legal person to make any construction over the what is property. Take seven to another section 5 application. What is the ground for making application? And you also can confirm the delay.
In their opposition, my lord, they have not taken any objection, my lord. In the latest judgment of Honorable Supreme Court, my lord, passed a few days ago, my lord, specific categorically parawise, my lord, denial has to be, my lord, to be done, to be there.
You are the respondent number 4.
Yes.
No denial, my lord, nothing.
Did not.
ওই লেটার যেটা প্রিন্ট আউট করেছিল ক্রিমিনাল নেট থেকে না হ্যাঁ কোথায় আছে কোন প্যারাগ্রাফ পড়েছিস না
Yes, what you have said in your opposition. You have filed an opposition.
No, assuming I have not been issued an evidence. So, Lordship kindly come to the explanation.
41, 41,
What is the explanation? You accepted that, my lord, your Lordship, I have the police report also.
Paragraph, which paragraph?
Paragraph 3,
Of Can 1.
page 3, paragraph 3 of
Can 1, sir. No difficulties. Can 1 is the stay, the
section 5 application.
Can 1 is
Can 1.
page 3, paragraph 3.
Yes.
We actually state that we put a cost on 30th of March to pass by Honorable
Paragraph 3.
Paragraph 2, my lord.
Yes.
Passed on 30th of March 2020. Passed by after for Master and Government Service knowledge of the applicant on 19th of December. He has no knowledge because that I have the document to the extent where he has no knowledge. Because police has filed a report in a contempt of he was duly intimated to the fact.
Okay. No, I am not party.
Directed the applicant to meet the system and prove a copy of the order and ask the applicant to according to the applicant number 1.
Yes. That's all.
What's the
Noted. Let us see whether explanation on
may I just at the end of your kindly give me another chance, I can produce some judgment order because your lordship was extended kindly extend the interim order for the period, but my lord, you also kindly grant me a chance. And opposition just stay application.
What are you talking about? You have filed your opposition, sir.
In regard to my lord, stay application.
Sir, you have also filed for stay. Look at it. You have filed for
Para 2.
But my lord, your lordship has
You have filed it, sir, written objection. They have filed a reply. The affidavits are complete. No, sir. No, sir.
Since your lordship has my lord, your lordship has my lord, as an argument.
That's a difficulty because that is what a genetic defect in me. Because I feel that more interaction at least augments the fairness and the transparency in the decision-making process. Unless we express our mind what is passing through, how the bench, the bar would correct us. We may be wrong sometime. That is what I feel that this kind of an interaction gives an impetus to an adjournment to the bar. What are you talking about? You should be ready with all questions that may come. Sorry, sorry. This section 5 we are disposing of.
Kindly give me one day. Kindly give me one day. Kindly take it more. Kindly take it more. I didn't tell something to not. I shall be, my lord. I shall be, my lord. It is my duty. I should be processed to that extent, my lord. I should be processed, my lord.
Tomorrow 10:30 first matter. Tomorrow 10:30 first. We will hear out the appeal and applications all together. We make it clear now you are live. We have a recording. We are making it clear that we will dispose of all applications, including appeal. We will not keep the appeal pending. Come ready on merit.
Okay, tomorrow 10:30.
But I'm appearing for the appellant. And a short for a compliance report of the Registrar General, the weather. And I have got some instruction.
What has come? Yes.
With regard to the documents exhibit, my lord, which have been withdrawn, my lord, these plaintiffs, the appellant before your lordship, the Sagor Sardar and the Gopal Sardar, my lord. And my lord, what happened, my lord? Their nephew, who is conducting the matter on their behalf, because my lord, Gopal Sardar is a blind man and Sagor Sardar is the aged man who is suffering from several diseases. What happened, my lord? He have instructed me that the trial court, the advocate, my lord,
There was a dispute whether why we called for the records.
because, my lord, on the last occasion I have submitted. Yes. Yes. He have instructed me that three documents have been
taken back.
one documents I have submitted the original. My lord.
Let us see from the record what we have taken back. You said only one document.
No, my lord. Last occasion, my lord, he have instructed me three documents. The
Where are all these three documents?
I'm telling you, lordship, the advocate who is conducting the matter, my lord, before the lower appellate court, Mr. Gautam Basu, who has expired sometime in the COVID, my lord. On 2010, there was an apprehension. Well, he has advised his client that there is an apprehension for tampering of the record.
9 and 10. 9 and 10. 2, 77, 2000. Yeah. Page 4. Six certificates. Yes, you have taken it back. Your lawyer,
Mr. Gautam Basu.
Santan Kumar Bose.
Maybe he is the son of Mr. Gautam Basu, who is conducting their matter. And I have been instructed that three documents he has been taken.
Give exhibit 9 and 10 back.
But 9 I have with me, my lord.
10 also you'll have to
10, that is, they have not instructed me. 10 has not been taken up, my lord. I tell you, lordship, what
in writing he has written.
But he has only instructed me.
We will
that
go by the sanctity of the record. We will
my-
go. We will
so
not
far to
go
the
what
record
you
is
say.
concerned, it has to be regarded as
What
sacrosanct.
do you say?
My
Your
lord,
instruction may be wrong.
my
Your instruction may be.
he has only instructed me three
Absolutely
documents he has taken. That is the give deed and
have
his
to give,
documents.
otherwise we will not. We will direct. Exhibit 10 will not be taken into consideration.
I will.
We will not allow exhibit 10.
Exhibit 10, my lord, he has not instructed me. Exhibit 10 here. This is the.
You have to give.
But I have
Wanted
instructed.
this.
My lord, I will
They said only
call
one
the.
document. We called.
Now I am
it appears
rectifying it, my lord.
in handwriting, you have said 9 and 10 both taken back.
He has instructed me three documents, the partition deed and the give deed also he has taken back.
Exhibit 9 and 10, it appears to us, has been taken back.
But this is a 9, but this is a sales certificate I have. Well, I have produced the original before my lord.
Oh. Again,
On the last occasion, I have produced.
Back, exhibit 9 and 10. We are unable to refile the same. With undertaking to refile the same. Because it must have been filed subsequently.
The problem is that with regard to the learned advocate who was conducting this matter, after his death, my lord, my client has gone. After several requests, he has only given back two documents. That is a give deed and the sale execution certificate.
It's for that. The only thing is that we will not permit you to rely.
Malad.
We will not permit you to rely this document, Exhibit 10.
Exhibit 10, Malad, I have, and I have produced Exhibit 9.
Exhibit 9, we will not.
And that is the order of delivery and execution order, Malad.
Let us see Exhibit 10.
Madam.
But 9 we don't have.
But Malad, he has only instructed that 9, he has not given me any instruction. He has only given me instruction. I gift it also is with the record, my lord. Then my lord, kindly accommodate me for 1 week or further chance only. I will not produce, the client will.
No, sorry, we will simply say that you will not be entitled. That is the law. If you do not, then you will not be entitled to rely upon Exhibit 9.
My lord, before that, my lord, kindly give me a chance, moment, time, my lord. Problem is that, my lord, the plaintiffs, the appellants, now they are not able to.
Let us see, today is for compliance.
My lord.
And in view of the direction passed by this court on 4th March 2024, the lower court record has been sent to this court. The compliance report filed by the Registrar General is taken on record. Let the appeal be listed for admission under order 41 in the next one. It is only for compliance that we have accepted. Take it.
So it will appear on the next week. Great.
But I appear for the appellant.
I appear for the respondent, sir.
Your Lordship have had occasion to see the judgment, after which your Lordship fixed the matter. I'll take your Lordship through it. I'll just give your Lordship a very short summary. But in this case, it's a infringement come passing of action. Lord, I have registration for vegetable oil of a trademark called Rishta. My Lord?
Relationship.
Yes, relationship. Now, I have been in the business for long years, my lord. There may be a dispute about whether it's 95 or 2000, but there are documents on record from 2000 onwards. I have been using it. There are advertisements in well-known newspapers. So, Lord, my user can't be doubted. I'm also in the field of atta and other such things. My learned friend's client, Lord, he is in rice. Now, rice. Now, I filed a suit for infringement and passing off. The learned judge has held not all the findings are in my favor, says I am the prior user, there will be confusion, there will be deception, he says all of that. And then he grants a injunction only with regard to not vegetable oil. He does not grant an injunction as far as other products are concerned. This is not the long and short of it. Now, not the simple way I intend to approach it is very clear. But he, or rather his predecessor in interest, he claims his rights over the trademark Rishta not on his own steam, but on the basis of an assignment by someone else. Now, he has a registered trademark for rice. In his application, he says very, very clearly that his claim for use of user is 2006. So on the basis of that admission, my lord, I am the prior user by far. So now what he does in his objection, and this is what the learned judge was swayed by, in his objection, he says, my lord, only one thing. It's the barest possible, my lord, written objection. No documents annexed, not one. Simply makes a bare claim or an assertion that his predecessor in interest has been using the trademark Rishta from 1995. Not one document in support of this so-called claim of user. Not one document. Now, the learned judge is swayed by this that, look, he has made a claim of 95.
that is to be decided at the trial. Therefore, there will be no injunction for other products. Now, that is completely contrary to the law. Now, I'll give you a lordship. I'm not 4 or 5 propositions. I give you a lordship. But forget infringement for a second. Or let's take 2 sentences of infringement first. Your lordship knows, my lord, after the new Trademark Act came into force, not the earlier small category of infringement was if someone uses a trademark for the product for which I am registered, it's an infringement. Now, under the new act, not the categories have been expanded. It will include not products which are agnate, cognate, close to it, similar, non-similar, different. Everything is now included within the not compass of infringement. That's one part. But not let's forget that. Let's look at not a simple situation of passing off. Here, not the principles are number 1, the prior user will always prevail. Number 2, it does not matter if the other person has a registration, because registration does not matter at all in an action for passing off. Now, prior user admitted his registration is of nothing. Number 3, my lord, it overlooks the fact, my lord, our special bench judgment saying that, look, trademark protection is not restricted to the same field of activity. It goes well beyond. So, my lord, given this, my lord, there is no option but to pass it, because, my lord, to pass an injunction covering it all. Now, my lord, before I take your lordship to the impugned judgment, I'll take your lordship to it last, because your lordships have had a chance to see it earlier, not about 10 days ago. But may I just take your lordship only to the written objection and 2 or 3 documents? I'll try and keep it not very short. Yeah. I've said that. Now, my lord, if your lordship would not please not first come to not page 71 of not the stay application. Now, this is annexed to my petition before the trial court. Or rather, my lord, if your lordship would come straight away to page 76. Now, this is my registration certificate. I am registered for vegetable oil, registered in the year 2010, and your lordship will find, my lord, user date 1st of April 2000. Lord, 3rd entry from the bottom, or 4th entry from the bottom, user date.
Above the device.
Yes, my lord. And the goods edible vegetable oil. So this is my registration. Now, my lord, if your lordship would come straight to, my lord,
31.
My lord, some documents I'll just show your lordship to show user. My lord, if your lordship will come to, my lord, page 79 first. Lord, advertisement in the Indian Express, page 79, 80. Your lordship will find, Lord, page 80.
Is the Airtel Express?
No, page 80. 80. 80. Lord, the next few pages, your lordship will find 2 or 3 more advertisements, not in newspapers. Then, my lord, billboards, hoardings, all those pictures are there. And, my lord, I've given my bills from page 91 onwards, showing sales. Okay. It's all right. It's all right. And your lordship will find, my lord, on top of the bills, page 94 onwards, the mark Rishta is displayed on the top left side. Not very clear, but not your lordship will have to, for the time being, take it from me. The top left side, before the word Kunj roller on the left side, not Rishta is.
Logo Rishta.
Yes, logo is there. And not all those bills are there. They are next, not they run into not many pages.
Sales figure.
But in the petition, my lord.
Have you made a compilation of year-wise
Yes, my lord. Yes, my lord. Please come to page 56. Page 56 onwards, that is also there. Petition.
Yes.
So, my lord, about this, there is no dispute. My lord. No one is getting into any disputes on this. Now, my lord, if your lordship would come straight away to page 144. That is his registration. Now, 2 or 3 things important over here, which I show your lordship. (144).
Date of application is
Yes, my lord.
2007.
2007.
The user detail is 2/10/2006.
2006. Very important. Now, my lord, your lordship will also find that the registration is granted in 2012. Now, that comes under certificate detail. Not just below user detail, certificate detail, certificate dated. Yes, that's when he gets registration. Now, Milord, before that, 2 other things over there, Milord. Kindly see proprietor's name, New Rishta Agro. Now, he was not the original applicant. New Rishta is the present defendant. His name comes in later, that I'll show your lordship.
Corporate or body corporate.
Body corporate, yes, that's what it ought to be. Now, my lord, the original proprietor was someone called Sri Krishna. That I'll show your lordship from the documents. So, New Rishta was not there. Now, my lord, your lordship will come a little bit below to goods and service detail, class 30 for rice. Now, my lord, your lordship will find history, PR details, pursuant to a request in Form 24, dated 14 July 2014, and order therein dated 20th July 2015, New Rishta has been brought on record as the subsequent proprietor in respect of the registered trademark. So he comes in, my lord, pursuant to an order passed on 2015. My lord. Now, my lord, your lordship will also find, now, my lord, uploaded documents, item number 8. Is a deed of, yes. So, an assignment takes place on 14 July 2014.
Application.
Yes, that's right.
On that date,
Correct. Now, my lord, what I'm trying to show your lordship is the little fraud over here, which is this. Original owner was one Sri Krishna, that I'll show your lordship. Now, he comes in and he becomes New Rishta. Please see.
That is his company's name.
Yes, he forms a company. He forms a company called New Rishta. He could have done Rishta. He knows I'm in the market.
Want to use any trade name?
Yes.
But so far as my mark is concerned, I can use it.
No, I'm not on that. The point I was making was, he knows I'm in the market. He could have called himself Rishta. He takes over a company. He takes an assignment from Sri Krishna.
But real. Just asking.
No.
If there is a proprietorship over the mark Rishta, whether that proprietor is known by some other trade name is a different thing. We do not know. We are concerned with the mark Rishta.
No, absolutely. Absolutely. Not absolutely. All I'm showing is, he calls himself New Rishta. Now, Milord, please turn to the next page. Your lordship will find now the original applicant. What did he have to say? Because he is claiming on the basis of this man. Now, Milord, the original proprietor was Naresh Kumar, trading as Sri Krishna Rice and General Mills. That's 145, page 145. That's his application. And, Milord, if your lordship turns the page 146, his user claim is 1st April 2004. Yes, which is not accepted by the Trademark Authority, because your lordship will find at page 144, he's taken it to be 2006.
Yeah.
So that nothing much turns on it, just pointing it out. And then, Lord, page 147 is his registration certificate.
Even if 2004 or a 2006, you are using it prior there.
That's not my lord. Now, my lord, please comes now straight away to his written objection, which is page 162. Only by denials, 162 it starts. Now, Milord, please comes to page 163, para 3, which says, before dealing with the allegations, respondent states as follows. And not the few things which he has to say, usual paragraphs. If your lordship turns to page 165 or 164, bottom of the page, Milord, the last para, on or about 29th March 2011, the respondent obtained registration under Government of India, so and so. So, Milord, it seems that he is probably formed his company on that date. It's not clear what this certificate is, but it's not a certificate of registration of trademark. That much is clear. Prior to the same, the predecessor in interest of the respondent, namely Sri Krishna of so and so, has been using the trademark Rishta under class 30 since 1995. In this regard, I further say predecessor has been registered by the Government of India, etc., etc., etc. And Milord, at the end of that para, the last 3 lines, products sold under the trademark Rishta recognized and preferred by the consumers in the market since 1993. Not just before subpara J. Just before that, the last 3 lines before that.
1995.
1995.
You said 1993. That's why I was just.
Oh, I'm sorry. I'm sorry, Milord. I misread that. Milord. And then he says significant reputation. That's last 3 lines of subpara J. Predecessor in interest of the respondent created significant reputation over the market and customers since 1995. Now, Milord, please note a few things. Your Lordship asked me the correct question. Have you given your sales figure? I pointed out. Has he given his sales figure? Nothing. Not 1 penny worth of sales even pleaded. Number 2, not 1 bill, not 1 advertisement for someone who has been in the market under this trademark for the last 30 years. 1 bare statement that his predecessor has been using it from 1995. That there has been continuous user thereafter. Nothing. Nothing. But let's take a academic situation. Let's say, he had started in 1995. He stops for the next 25 years and he starts today. Can he claim that advantage of prior user? Answer is no. The test is continuous and substantial user. Now, in this case, Milord, other than this, there is no document annexed. Nothing. Now, I can take your Lordship to the end of this. Your Lordship can take it from me. It is only bare denials thereafter. Only bare denials. The affidavit ends at 182.
Most important thing which we find is that if his predecessor in an application for registration has shown that he has been using since 2004, can he take a plea which his predecessor has not taken?
Absolutely. It's a fraudulent stand. And what the law in this area is very clear. He who asserts prior user must prove it with cogent evidence. That's the established law. Our High Court, Division Bench, all other High Courts.
Fundamental principles so far as the
My Lord, whoever asserts prior user has to prove it. Not a piece of paper. But this is all that there is on facts. I don't think I need to show your Lordship anything more. Thereafter, notes of arguments and judgments are enclosed. But this is the situation. Now, from here, my Lord, if I can take your Lordship straight to the impugned judgment, my Lord. If your Lordship would take the memorandum of appeal or
memorandum, yes. If we are interrupted.
So, my Lord, the submission is recorded of both parties and the arguments. And then, my Lord, if your Lordship would come to, my Lord, straight away to, my Lord, page 7 of this.
Last 2 paragraphs.
Yes, my Lord. In this case, it is the case of the petitioner that the defendants are trying to grab the business and goodwill of the petitioner company by using trademarks similar with the registered trademark, and the plaintiff is apprehending loss and damage, etc. Then, my lord, there is a serious question which needs judicial probe and adjudication. Then, my lord, refers to BS Progressive versus SG Sales. Honorable Apex Court held that in a list involving a dispute regarding passing of action, where the prior user would have its say.
Apex court.
My lord, I'm sorry.
How could it be an apex court?
STC Online Calcutta. Yeah, but it went up to the Supreme Court. I know that for a fact, my lord. Where the prior user would have its say, it would be too early to conclude finally who is in the business earlier than the other. Let it be decided at the proper time. Plaintiff should be given full opportunity to prove his case as to prior use. The defendant would also be entitled to defend. Now, what it has to do with our case, my lord, I don't know, because he has shown nothing. I have proved my case. Then, my lord, as per section 27, no action for infringement of unregistered trademark can be brought. No person shall be entitled to institute any proceeding to prevent or to recover damages for infringement of an unregistered trademark. However, nothing in this act shall be deemed to affect the rights of action for passing off of goods or services as the goods of another person, provided by another person, or the remedies in respect thereof. But passing of actions in respect of unregistered trademark is permissible in light of section 27. Grant of interim injunction is permissible in case the plaintiff can prima facie show that it was the prior user of the mark and balance of convenience is in its favor. So he cites the Supreme Court judgment, but this is clearly in my favor. Then passing of action is essentially an action in deceit, where common law rule is that no person is entitled to carry on his business on the pretext that the business of another. Three ingredients are goodwill owned by the trader, misrepresentation, damage to goodwill. Passing off in common law is considered to be a right for protection of goodwill in the business against misrepresentation caused by the course of trade and for prevention of resultant damage and misrepresentation. Not another Supreme Court case. In the case of right of prior user vis-a-vis prior registrant, it is to be found out which proprietor had generated goodwill by way of use of the mark named in the business. Examination of rights in common law based on goodwill, misrepresentation, and damage are independent to that of the registered rights. Use of mark carrying on business under the name confers right in favor of the person and generates goodwill. Hence, later use of the mark cannot misrepresent his business as that of the business of prior user holder. So, my lord, the principles are laid out correct. Then, my lord, the findings from here. I find that there is a bona fide contention of the plaintiffs as regard likelihood of causing confusion among customers and loss of business if defendants are permitted to use the registered trademark Rishta along with design as stated in the certificate dated so and so in respect of edible oils for their personal gain. Considering the demand of the situation and urgency of the matter, I feel that the plaintiffs immediately needs a cool whip of preventive injunctive order for the purpose of protection of further damage of their trade and goodwill of their business, which cannot adequately be remedied by money value. Otherwise, if the plaintiffs are made to wait, then plaintiff would have to face disastrous consequences. On the contrary, it would be tantamount to permitting the defendants to represent his good merchandise as goods of the plaintiff by using the mark symbol which is registered in favor of the plaintiff. Therefore, I am convinced that the plaintiff company is under perilous exposure to harm, and they say, and they have prima facie case in respect of registered trademark Rishta, along with design as stated in so and so, dated so and so in respect of vegetable oil, and prior user from 1st April 2000. So finds that. But on the other hand, defendant has prima facie established his right over the trademark Rishta for rice products under class 10 since 2712 and prior user from 210-2006. Now, how can it be prior user? He is himself noted 2000 is my user. He himself notes it. Admittedly, application of both parties for registration of the mark Rishta in respect of various articles apart from rice and edible oils are pending before the concerned authorities. Moreover, contention of the parties as regard use of the mark since 1995 or from 2000 can only be proved by cogent evidence. Now, he says that, but doesn't look for any evidence on their part. In case of conflict between two registered owners of the same similar trademark, exclusive right to use is not available to one against the other. The other registered owner has the same rights against third persons. Hence, plaintiff cannot say its registered trademark is infringed only on the ground of registration of its trademark when defendant is also enjoying registration and such registration also gives the right to the defendant to use the same as provided in 28(1), unless plaintiff can establish a superior right at common. Not what has happened to the law of passing off. He cites all those judgments. He says, look, it can't be infringement as far as Rice is concerned because he is registered. But what happened to passing off? Vanished. No finding. Hence, in view of such, it would not be prudent to pass any blanket order of preventive injunction in respect of other articles, apart from rice and edible oil, without considering evidence of the parties at this stage. Now, here also, my lord, look at the way the sentence is structured. It sounds like I've got an injunction for rice. Please read it. Hence, in view of such, it would not be prudent to pass any blanket of order of preventive injunction in respect of other articles, apart from rice and edible oil. So it sounds like I've got an injunction for rice, but the later part, not again, is odd, without considering the evidence at this stage.
So it's only says edible oil, vegetable oil.
Not if one goes by this, it's rice and edible oil, or it's nothing, frankly. But even if one corrects that sentence, I probably don't have an injunction for edible oil, although his intention is clear. It covers edible oil, but the language is wrong. So
You have been provided with the edible oil, but conspicuously the rice is missing.
that's absolutely. But going by the language of the order, apart from rice and edible.
That means there cannot be a blanket order of injunction.
Your lordship is right.
In respect of other articles, apart
Absolutely.
from means blanket order in respect of other articles, but blanket order can be passed in respect of rice and edible oil.
But if your lordship says, well, I've also got it for rice, it will also be helpful.
Read that.
Yes, that's how it reads. Your lordship is right.
Prudent. First thing is a negative.
Yes.
It would not be prudent to pass any blanket order of preventing injunction in respect of other articles.
Correct.
Means no blanket
Apart
order.
from rice and
Apart from rice and edible means that rice and edible one can pass such blanket order.
yes.
And then rice is conspicuously absent in the operative portion, is only the vegetable oil.
Yes.
This is what
Yes.
you wanted to say.
Yes.
Don't take it what we say.
No.
That is what
This is what I was trying to. But so therefore, my lord, I need a cool whiff of preventive injunctive order, my lord, and we need some cool whiff of air also. The way it's turning hot now, but my lord, this cool whiff of preventive injunction is necessary in this case. Now, my lord, I'll have to trouble it.
So you need a hot whiff. Why cool?
But one has to keep cool when one is in court, not outside. Again, one has to stay cool because all the heat comes from the other half. So, Lord, one has learned to be cool, Lord, with time, Lord. Now that I'm a senior citizen, Lord, I've learned that it's helpful to remain cool, Lord, and every cool whiff of Lord injunctive order helps.
You acquired a status of a senior citizen or before that?
But I think after. But before that, I was known a little bit for some colorful language here and there, but not that.
In all sphere of your life.
Now, Lord, I think, Lord, I'll have to trouble your lordship with some, Lord, judgments. They all refer to over here. Lord, I know your lordships are cracking a joke at my expense. Your lordship can, Lord, ensure I'm the laughing stock amongst not the juniors here also, Lord. I have no difficulty. Now I've learned to take everything with a smile, Lord.
No, it's not a laughing stock. It was something which we're aiming at somewhere. Not restricted to this pudding which here on your professional side. Every time, not after it acquired the senior citizenship, throughout the life.
But always necessary. Always necessary. Although there's something, not when one thinks back, I don't think I've seen someone
Yes. You're 15.
Difficult. Defendant or the appellant before your lordship. Judgment or reversal.
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 What is the nature of the suit?
Suit for declaration and injunction in respect of property in question, where the defendant filed a counterclaim, praying for a declaration that the deed is loan in substance, not an out and out sale. Under being on mindedness. Trial court dismissed the suit and dismissed the counterclaim. Against that, one appeal has been filed.
Yes. And then?
My lord, then this is a
reversed.
It is reversed.
Res judicata. The appeal shall be heard on the following substantial question of law. Whether a single appeal against a judgment and decree passed in a suit as well as the counterclaim is maintainable. Next, whether the principle of res judicata would apply if the appeal is filed, if one appeal is filed against a judgment and decree passed in a main matter as well as the counterclaim. Then usual, what is the application? No application.
Application for injunction, my lord.
What injunction?
Because
whether you were
enjoying position.
Whether you were enjoying any injunction during the pendency.
No, it is better to sub copy because from the documents, my lord, I cannot
serve copy, returnable after 3 weeks before the appropriate bench. Next.
The plaintiff is the appellant before your lordship.
Plaintiff is the appellant. Judgment of affirmance.
This is against my remand order.
Order of remand, FMET.
Yes.
What's done by the trial court? Decreed the suit or the
decreed the suit
and remanded.
Remanded.
What is the nature of the suit?
Suit is, my lord, that petitioner, plaintiff is a Shivaith trustee in respect of estate of Judicial Siddharth Jeev Thakur, which was installed by his.
What is this miscellaneous case?
Miscellaneous case as arising, my lord, out of the section 34
of the Indian Trust Act.
Trust Act.
Then a miscellaneous case for what? It's a vacating the interim order or what? What is miscellaneous case?
No, the trial court decreed the suit, and my lord, a suit for declaration.
Was there any objection raised that the no permission should be granted?
Yes.
It's an ex parte one.
That permission has been granted.
The leave was granted to sell the trust
Yes,
property.
Yes.
Then
Because
what miscellaneous case?
Miscellaneous case arising out of the application under section 34.
No. 34 was disposed of by the court.
That's right. That's
Correct. Then what is the miscellaneous case?
Miscellaneous case.
What application? Because that is disposed of, 34 gone. Then what is the miscellaneous case?
Miscellaneous case is not the
141 talks about the provision of the suit will be applicable to a supplementary proceeding. 145. That is what.
Because the
then this is really an order 1930.
miscellaneous case, my lord.
I am really perplexed with the opening words or sentence of the impugned order. It says that on the basis of a petition under section 141.
And on
141 talks about the miscellaneous proceedings and the provision of the suit would apply to a miscellaneous proceeding.
For vacating the interim order.
145 talks about enforcement of the liability of the surety.
Yes.
Both I do not know.
Anyway, my lord, this has been couched in that fashion. I do not know.
I was also, then miscellaneous case means I can understand that you wanted an ex parte judgment to be recalled, to be set aside.
Yes.
If it is an order 9 rule 13.
No, this is not order 9 rule 13.
Then what? Under what provision ex parte decree can be set aside?
No, because my lord, the court allowed miscellaneous case originated out of an application under section 34 of the Indian Trust Act. The opposite party of the instant case Navin Sarkar was the petitioner of the said case being 83 of 2002. He was permitted to sell the property.
This is what he wanted, 10 to 2005.
Person offending highest
case number
market price.
Was registered as a miscellaneous case. 34, right of appeal. What is the right under the Trust Act? Is there any provision for an appeal against the order under section 34?
No, I have.
No, if it is not,
Yes.
if it is registered as a miscellaneous case, then whether any right of appeal emanates? I am asking you a very simple question. It's under the Trust Act. Is registered as a miscellaneous case. That is what I am asking. Indian Trust Act, I believe, does not contain any such provision. Section 34. Trustee property cannot be sold. Right to apply to the court for opinion in the management of interest. Any trustee may, without instituting a suit, apply by a petition to a principal court of the opinion, advice, and direction respecting the management and administration of the trust property, other than the condition of detail, difficulty, or importance not proper in the opinion of the court was settled. Copy of such petitions shall be served. May be attended by such persons interested. Trustees stating in good faith, such as says the cost of it. There is no problem. Suppose this is not by a suit, but by applying a petition. If it is an application, the right of appeal must be there. With the right to it, that is what I'm asking you. Under this, I don't think so that there is any provision for an appeal under the Indian Trust Act.
No, kindly.
If that is the position, section 34 clearly says without instituting a suit.
Exactly.
That means the suit, but by way of a petition. If it is by way of a petition, and there is no right of an appeal, then what is the remedy which is available to a person aggrieved thereby? I'm asking this question. That is the pertinent, that is the question I'm asking you. Suppose section 34 is disposed of on contest or ex parte or whatever, dismiss. Then what is the remedy? Because it is a petition, it is not a suit.
Yes.
If it is a suit, then section 96 of the CPC is a decree followed by a decree, no difficulty. Appeal live. But if it is not, then in that event, what? What should be the remedy?
The other side filed the miss appeal.
But
I am
you have filed an appeal.
I am
But now I'm questioning whether the appeal lies against an order.
Yes, my lord is perfectly right. But my lord, question is, I have not preferred any appeal.
Oh, Mr. Rokit, you are a veteran in the civil side. You should understand what is troubling me is this. They have approached the wrong forum. Suppose if they have approached the wrong forum, then what is the remedy? They have not filed an appeal. It is a miscellaneous case. You are challenging that order passed in a miscellaneous application.
Yes.
Now question is that you have not gone for an appeal.
No, I have not.
You have not. You have really taken shelter before the same court for recalling an ex parte order. Order 9, Rule 13 talks about a procedure for setting aside the ex parte judgment or judgment. 144(1) says that the procedure provided for a suit shall also be applicable to a miscellaneous proceedings. So, you may not have referred Order 9, Rule 13, but in effect, the principles of Order 9, Rule 13 applies. So, this is in effect Order 9, Rule 13 application. Now, this application has been rejected. The application is rejected. The question again arose. Though rejection of an Order 9, Rule 13 is an appellable under Order 43. But if the remedy of an appeal is not provided against the parent order,
yes,
whether the remedy of appeal can apply against a miscellaneous order. I'm talking about the principles of, the Privy Council. If the remedy of appeal is not provided against the final order passed in a proceeding, then the appeal also would not apply against any order passed either in a miscellaneous proceedings or in an interlocutory proceedings.
Then what?
Your senior argued and successfully argued before the division bench. He raised this point. He said, no, it cannot be.
Then what is the remedy?
If the appeal is not the remedy, then you know what is the remedy. There are certain provisions which says that where no appeal lies, then
No, the instant miscellaneous case, Lord 25 of 2011 was registered on the basis of the petition under section 141 and 151.
What is 141, sir?
41 and 40.
What is 145? I am really surprised and shocked whether 145 can be applied. What is 141? 141 is that the provision relating to suit shall apply to a miscellaneous proceedings as well. So it is what the provisions relating to suit has been extended to a miscellaneous proceedings as well. Yes, no difficulty. So one can think of that if it is an ex parte decree in a suit, then to set aside the ex parte decree, what shelter, what provision?
No, originally, my lord, the suit was compromised.
No, sir, you are assailing an order number 20 dated 10/2/2005.
Yes.
The operative portion of the order is the application under section 34 of the Indian Trust Act is allowed ex parte. Now, if it is allowed ex parte. You wanted to set aside the ex parte order. Sir, you have preserved this.
Yes.
By making a lamination. Just imagine such an important order. You have laminated it. So it's an ex parte order. First foremost question is that what is the remedy available to a person against an order passed under section 34 of the Trust Act? First question. Trust Act does not provide any appellate provision. Bus 34 says not by institution of the suit, but by making a petition. So naturally it is registered as a miscellaneous proceeding. If a miscellaneous proceeding is decided ex parte, whether the appeal lies, appeal is a creature of the statute. Unless the statute provides for an appeal, nobody can. Then what is the remedy? Secondly, if one chose to recall the ex parte order, then the only provision in the Code of Civil Procedure is Order 9, Rule 13 relating to suit. That is the only provision. Ex parte decree can be set aside. But by virtue of 141, this provision relating to suit is also extended to a miscellaneous proceeding. So one can also think of that recourse under Order 9, Rule 13 can also be taken. It is in the nature of Order 9, Rule 13. Principles of Order 9, Rule 13 will apply. Now the court, second question is, if that miscellaneous case is dismissed. Under Order 43, if it is treated as under Order 9, Rule 13, rejection is an appellable order.
Yes.
But principle is that if the appeal is not competent against the parent order, then the appeal would be maintainable against an order refusing to recall that parent order. Yes.
In any way, my lord, the court was pleased to allow the application under section 34.
Ex parte.
Ex parte.
Then,
Ex parte.
then.
And petitioner was permitted to sell the property.
It's true. I am again saying there is no difficulty. But the remedy. Mr. Mukherjee, that Justice Bhaskar Bhattacharya's judgment that if the remedy against the parent order is not an appellable one, then against the interlocutory or miscellaneous order, appeal would not lie. That was a case of Order 39, Rule 1 and 2. That principles have been laid down. I don't have I know the judgment. I know, but now I can't recollect the citation. And his senior was instrumental to that argument.
That was in the context of Order 39 Rule 1 and 2.
That was there in miscellaneous order. That is applicable under Order 43, but that would not apply. That will not apply. Where is Mr. Ghosh and Mr. Roy? Mr. Sivasis Ghosh and Mr. Devashish Roy?
But the present appeal arises out of the Order 43 Rule 1U.
It is a petition under Section 141. Let us go. Now we go. Your petition is 141. Whether Order 43 talks about 141? Then how the appeal lies? That's the only point. Nothing more than that. We appreciate everything, but only thing is the jurisdiction and the competency of the proceedings. Nothing more than that. And the second thing is, Order 9 Rule 13 has been allowed. That too does not come under Order 43 Rule 1. In both ways, you are, even if we treat it under Order 43, no appeal lies. I didn't notice actually. I just thought that it has been rejected. But now I find it is allowed. Then whether the Order 43 contemplates any appeal? No. So in both ways you do not come. What to do?
I leave it to you.
What?
I cannot develop.
What? Tell us what to do.
I leave it to you, Lordship. I have no answer to that. Because if that is so, or my Lord, kindly allow me to serve a copy of the other side.
It will be doing an injustice, contrary to law. The instant appeal is filed. A sealing and order number 114 dated 12/6/2023 passed by the London District Judge Hooghly in miscellaneous case number 25 of 2011, by which an application for vacating the ex parte order dated 10/2/2005 passed in miscellaneous case number 83 of 2002 was allowed, and the original miscellaneous case was restored to its original file. The record would reveal that the said miscellaneous case number 83 of 2002 was registered on an application filed by the, you are the petitioner. You are the petitioner of that application. What is your name?
Naveen Sarkar.
Naveen. কি বলেছে?
Was subject to correction.
Was registered
Have other remedy
on and filed by the appellant petitioner under section 34 of the Indian Trust Act, seeking a permission to sell the immovable properties to the persons offering highest market price on the condition that 2/3 of the sale proceeds to be invested with the nationalized bank. Mr. Ghosh, do you remember that judgment of Justice Bhaskar Bhattacharya, as his lordship then was, where a point was taken by the senior of Mr. Ruke, Mr. S.P. Raju, that if the remedy of an appeal is not provided against an order passed in a main proceeding, then the remedy of appeal cannot be provided against an order passed at the interlocutory stage or the principles borrowed from the Privy Council. I know who says it is not. I read that judgment from the report. It's not that I have not read that judgment from the report. Just now we wanted, if you can. Anyhow, keep it. No. Seeking a permission to sell the immovable properties. Oh, to the no, on the highest market price. Full stop. The said application was disposed of ex parte on 10/2/2005, permitting the petitioner to sell the immovable properties to the persons offering highest market price on condition that 2/3 of the sale proceed to be invested with the nationalized bank in a periodical interest earning fixed deposits in the name of the DT to be operated by him during his lifetime and subsequently by the person or persons to be nominated by him. It was further indicated that the periodical interest shall be utilized exclusively for daily Seva Puja of the DT, and 1/3 of the sale proceeds shall be used for renovation of the temple. They said, subsequently, the respondent herein took out an application seeking vacation / setting aside of the order of the said ex parte order, which was registered as miscellaneous case number 25 of 2000. Though the said application is, though the nomenclature of the said application is given as an application under section 141 and 145 of the Code of Civil Procedure, but in effect, it is an application to set aside this party. So, section 144 of the code postulates that the provisions relating to a suit would also apply to miscellaneous proceedings. Obviously, the principles relating to a provision applicable for the suit shall also apply in case of a miscellaneous proceedings. The right of appeal emanates from a statute. Stop. The party cannot choose the remedy of an appeal if the same is not provided in the act applicable in this regard. It is sought to be contended before us that by virtue of section 141 of the Code, the principles of Order 9 Rule 13 of the Code applies. And therefore, the appeal would lie against the said order. Though we are not convinced with the aforesaid submissions, but even if we accept such contention to be correct, the right of appeal does not appear to have been conferred by virtue of a provisions contained under Order 43, Rule 1, within bracket D of the Court. Stop. The right of appeal is only conferred when an application under Order 9 Rule 13 of the Court is rejected and not when the said application is allowed. Going by the aforesaid principles, we do not find that the appeal is competent কি বলেছি? Stop. We therefore we therefore, in our opinion, the proper remedy lies by filing a revisional application under section 115 of the Code of Procedure, and therefore in order to ameliorate any complications, we hereby direct the instant appeal to be converted into an application under section 115 of the Code of Procedure. The office is directed to not 227, 115 would lie. The office is directed to the department is directed to give a proper number assigned to the revisional application. Stop. In the event the department finds that there is that the court fees. What is the court fee leviable on 115 revision? 250.
227. 120 is for Article 227.
250. And revisional the same. I believe there cannot be 115 also the same.
They say they pay 220 the same for 227.
কি বলেছি? কেটে দাও এই যে ওখানে বলেছি to convert it. The file shall immediately be placed before the stamp reporter for ascertainment of the deficit court fee. In the event the stamp reporter notifies the deficit court fee, the same shall be put in by the appellant within fortnight therefrom. The language of 115 is that where no appeal lies there too, then it is a revision under 115. And proviso says that if by the order it has been finally disposed of, then you have the remedy by way of 115. Because the proceeding has been disposed of by this order. Yes.
This is my appeal, but I am appearing with Mr. Bhattacharya. He is appearing in the virtual mode with me.
Who will argue, you or Mr. Bhattacharya?
I'll be.
The reason is well known that there may be some very difficult questions asked by us to Mr. Bhattacharya, who appeared in the matter on last two occasions. And then the decision has been taken to bring you, I believe so.
But may not be in this matter, Lord, maybe other matter.
This matter, I believe. Ask Mr. Bhattacharya. Yes, unmute your system.
That was a different matter, my lord. That was a surfacey matter.
Is there any statute like Act Civil Procedure Code
Did they write that on the, my lord, the sheet?
Mr. Bhattacharya, can you, who is a junior? Mr. Abhilash Chatterjee. Give me that book. I am ignorant of this statute. Both of us, we have not read Act Code of Civil Procedure, a Civil Procedure Code. We do not want to remain ignorant throughout our life. Please give me that book. You must have read it. Give me, please. We want to enhance our knowledge.
But I kindly grant him liberty to correct
What?
that, Lord.
We want to read. We have not read it.
Acronym.
Please
So
pass
we
on
wait
that
that
book,
way.
sir. Pass on that book. You must have.
Don't take it casually. These are
এই পড়ে গেছে কাউকে পাঠাও
here.
এই ধরাও দাও ওনাকে
দায়িত্ব তো যে সই করেছে
What he's doing is a court's document. Mr. Mukherjee, he can't put
no, Lord, he did not touch it, Lord. He was about to. Just stop.
Can't. Yes. So give us.
I tender apology, Lord. That's a.
No, I am conscious
And
what has been done. I am
even here,
conscious.
even Lord, even I'm ashamed to say that, Lord.
Yes.
The reason
I
that
know
yes,
what is the real thing. We both were there for a pretty long time. You know.
Now that when he
Who
signed,
does, and then with the closed eyes, who signs, is well known to us. It's not that we don't know. Before putting a signature, one should.
That is.
What is the matter about?
Lord, I am the defendant number 1 and 2 in a suit for partition, and I am challenging, Lord, an order of remand, an open remand by the first appeal court. But the trial court dismissed the suit, where I was the defendant. The dismissal was on the ground, Lord, that the purchase of the property by the plaintiff, where he seeks partition, was, Lord, by metes and bounds. There was a definite, Lord, boundary given in their deed. Therefore, this was one of the reasons by the trial court.
Whom they purchase?
Lord, from a common, Lord, vendor. I mean the common predecessor in title. Now, Lord, the suit property is plot number 1207. Originally, Lord, it was about 8.42 acres.
Suit property is 12?
1207, plot number.
1207.
1207. It was originally the entire plot is, my lord, 8.42 acres. Of which, my lord, 1 acre 51 decimal is, my lord, the subject matter of co-scheduled property. 1 acre 51 decimal is the subject matter of co-scheduled property. Out of which 99 decimal co-1 schedule was, my lord, the property which is, my lord, sought to be partitioned. This was, my lord, the area which the plaintiffs claimed to have purchased. 99 decimal in 1207. In one of the plots. The learned judge, my lord, dismissed the suit primarily, my lord, on the ground that, my lord, that they had purchased with the boundaries well demarcated. One. Secondly, my lord,
Not a good ground. Next.
Another ground is, my lord, that because they did not ask for recovery of possession from my client, who had admittedly in occupation, there was another reason.
Does not lie. Then
Then that's the reason, my lord.
Then-
Other reason is, my lord, that all the, my lord, the vendors or, my lord, the persons who own, my lord, the property were not arraigned as a party. There was a misjoinder.
not misjoinder, non-joinder.
Non-joint. Non-joint.
Non-joinder of the co-sharer.
Co-shares. That was, my lord, the grounds
One of
on
the
which,
valid ground. Then
now, my lord, it was carried in appeal. My lord, kindly see, my lord, the appeal court's order, page 8 and 9, internal page 8 and 9.
what did
But
say?
there were, my lord, 3 witnesses of the plaintiff. There were 4 witnesses of the defendant. The documents were there. The learned judge, my lord, made an open remand. My lord, without any basis, my lord, it could have, my lord, decided the appeal itself. Either way. But internal page 8 and 9, my lord, of the appeal court. Appeal court
Whether everybody, the defendants also purchased from a common vendor.
Yes, my lord,
Common vendor was one or multiple.
but I tell you, lordship, my lord, Indubala Ghosh was, my lord, the owner of, my lord, 8.42 acres.
She alone.
She alone. She
Then-
gifted 1.51 acres to Amulya Ratan Mahapatra
With demarcation.
with demarcation, means, my lord, the boundary demarcation.
Correct. That is what I'm asking.
Lord.
Yes. With demarcation.
Lord. Lord, that was in the year 1967.
Correct.
Then Amulya Ratan Mahapatra sold 99 decimal on the northern part to Saroj Kumar Roy on 1968.
With demarcation.
But this is, my lord, I need to check it. I need to check that.
Yes.
Then, my lord, Amulya Ratan Mahapatra sold, this is, my lord, the case of the plaintiff. That, my lord, the sale to Saroj Kumar Roy, that is the predecessor in title of the plaintiff. Now, my lord, that was in 1968. Then, my lord, the defense case, that is my client's case, was, my lord, that Amulya Ratan Mahapatra sold entire 1.51 acres, which he got from, my lord, her mother's sister, that is Indubala, to Surendranath Bishwas in the year 1969. Then Surendranath Bishwas sold the entire 1.51 acres to Shankar Prasad.
So the Amulya sold it prior to 69 to the plaintiff's predecessor.
That was, blood in respect of 99 decimal in 1968.
Out of 1.5, 1 acre, 56 decimal. Out of that, he sold 99 decimal to
Plaintiff.
the plaintiffs or
Plaintiff.
plaintiff's predecessor.
Yes.
No difficulty.
No
The
difficulty.
rest was sold to
The entire was sold, my lord, to two
subsequent
persons. Subsequent thereto
thereto.
in 1969.
Can it be now?
Now,
which
my
will
lord,
prevail?
the 68 deed was the subject matter of challenge, whether it was at all, my lord, sold or not. That was.
Then
Then, my
what
lord,
route?
how I got the title, I preempted the procedure. After, my lord, the second sale was done, I got a order of preemption. By
Who are
virtue of
you?
the court's order, my lord, I am the defendant.
That I know. Who are you means the preempt means
No, I'm the
adjoining
preemptor.
owner,
I'm the
what?
preemptor as a co-sharer.
As a co-sharer.
Co-share.
How you become a co-sharer?
But because I own, my lord, the averting properties.
That's an adjoining owner. Say that.
No, my lord, in respect of this, my lord, this
Now I
particular
understand.
1207, my lord, as I said, my lord, it is a
I do
big
not
plot of
know,
land.
because what I am why I am asking you is a very simple thing.
Lordship.
A person who owns the entire property, say the larger, he wanted to sell the property in fragmentations. And the moment he fragmented those properties, then he cannot be a co-sharer of his purchaser. Cannot be. So it is an automatic fragmentation that has occurred. And thereafter, if he sold the others, then if the vendor means the original owner cannot be a co-sharer of his purchaser, then the subsequent purchaser from that owner cannot be a co-sharer. It is really a demarcation.
Now, my lord, there are two things. My lord, here, my lord,
So
the
that is what I was just thinking in that line, because you said that Indubala was the owner of 8.42
acres.
2 acres. Out of 8.42 acres, he sold 1.56 to Amulya.
1.51.
Whatever.
To Amulya, yes.
56 or 1?
1.51.
1 to Amulya. Amullo, out of 1.51, sold 99 decimals to the plaintiff's predecessor or plaintiff. Now, if the Amullo got the demarcated property from 8.42 acres,
Lordship.
then the Amullo has a standalone right. Because Amullo cannot be regarded as a co-sharer of Indubala. Nor the rest of the properties, if sold by Indubala to a third party, they cannot be a co-sharer of Amullo. Now, if Amullo out of 1.51 sold 99 decimal, then the rest, if he has sold with the demarcation that he can do, then the same principle would apply in respect of the remaining property. The preemption, I was just wondering that whether it has been allowed or it has been.
It was allowed. My lord, I got, my lord, the deed, my lord, executed, my lord, by virtue of the order of preemption. But there, my lord, there are two things. My lord, I claimed on the basis of, my lord, the co-sharership as well as, my lord, the contiguous ownership. map
इसके अंदर अब आप जैसे आपने this is also published because you are the sole owner of this.
My lord, if your lordship kindly comes to the appeal court's order, my lord, all that I say, my lord, the appeal court should not have my lord, remanded, my lord, on an open remand when, my lord, the materials were all there. But the learned judge has recorded about, my lord, how many witnesses were there, the documents were there, and the reason for the remand, your lordship will kindly see.
You bring the other side.
Lordship.
We are not admitting at this. We can after if they come, we can think of deciding the matter by the appellate court itself. Don't worry. So we can set aside. Otherwise, if we admit a premium is given,
Then,
that
my
the
lord,
suit
kindly
would
grant
remain
a stay in
for-
respect of the proceeding in the trial court. But in the trial court, आगे दिन order था देना trial court যেটা দেখা ওই দেখো
You serve the short notice and come back.
very well. মেদিনীপুর কবে করতে পারবি? হ্যাঁ এক সপ্তাহ যেতে যা টাইম চার
2024 The instant appeal
তো এটা আগের দিন একটা
is
প্রিন্ট আউট
filed.
এনেছিস
The instant appeal is filed by the defendant, one of the defendants.
two of the defendants out of three.
By two defendants assailing an order of remand passed by the first appellate court. According to him, there was no better on the part of the appellate court to decide the issue on the basis of the evidence as well as the other available documents. And therefore, the order of remand needs interference. After considering the gamut of the dispute and the stand of the parties in relation thereto, we feel that if the appeal is admitted, it would unnecessarily delay the justice. Stop. We thus feel that before admitting the same, the plaintiff respondent is required to be notified, and therefore direct the appellant to serve a copy of the memorandum of appeal as well as an application upon the plaintiff respondent.
Number one.
Why
Plaintiff-
number one?
Because, my lord, the other one is, my lord, he was one of my director, the respondent.
The
number.
plaintiff respondent we said.
Very well.
Plaintiff respondent is one.
One.
Plaintiff respondent by speed post as well as through the learned advocate representing, is a company or an individual?
No, he's an individual.
Representing him in the trial court, indicating that this the matter that is the matter would be listed on 16th of April under the heading Order 41 Rule 11 of the court.
যদি না হয় তাহলে ট্রায়াল কোর্টকে একটা চিঠি দিয়ে বলবে 20 তারিখে হয়ে যাবে। আই এম গ্রেটফুল।
My lord, learned counsel Mr. Nilanjan Bhattacharya is appearing through the virtual mode, my lord.
Yes, let him. We never deny anybody appearing on virtual mode. Yes. Have you treated the left out parties?
Yes, my lord, the last question it was.
What is the matter about?
My lord, it's a judgment of affirmation, my lord, suit for eviction of licensee, and my lord, the appellant is the defendant in the suit, my lord.
Yes.
No, my lord.
What is the ground?
My lord, I tell your lordship, my lord. My father, it is the case of the plaintiff that my father sold the property in, my lord, August 22 in 1944.
August 22, 1944.
44 in favor of the plaintiff.
Correct.
But my lord, the possession was never handed over.
Correct.
Now in 1980, my lord, after the death of, it is the case of the plaintiff that they allowed my father as a licensee in the suit property.
Correct.
In 1980, when my father died, they allowed the defendant as a licensee in the suit property. And in 1992, a deed of partition was executed between plaintiff and the defendant.
Defendant partition?
Yes, my lord. This is the very interesting part of this matter. Deed of partition executed between the plaintiff and the defendant.
Yes.
Where the defendant was declared as a co-sharer. A declaration was also sought for in that suit that this deed of partition is not binding upon. Now, my lord, the ground what I have taken in the suit as well as in the appeal, that though, my lord, in the year of 1944 the deed was, my lord, executed, this is, my lord, undisputed fact that my father executed the deed. Though, my lord, the deed was executed, but it was not acted upon.
What happened to 1980 suit? What happened to 1980 suit?
My lord, 1980, there is no suit in the year of 1980. My father died in the year of 1980. A suit filed in the year of 2013. Both the court below, my lord, held, my lord, that I am a licensee and, my lord, give a, my lord, decree for eviction. Now, my lord, I have threefold point in this matter. Number one, my lord, 1944, my lord, though the deed was executed, it was never acted upon. And, my lord, my father hold the property in adverse possession with the best knowledge of the owner. And, my lord, considering my lord, adverse possession, the deed was executed in the year of 1992 as a co-sharer in the property. And secondly, my lord, both the court below failed to consider the point of limitation in all the cases.
What limitation?
Limitation regarding since I am in adverse possession of a property, there is a limitation of 12 years in terms of section 65 of the Limitation Act. But it was in
That limitation is applicable to a person who is claiming an adverse possession.
I am claiming, I'm
After 12 years, he can claim an adverse possession.
And the third point
does not apply anyhow. Yes.
And the third point of is that both the court below hold that since I am claiming the adverse possession as well as from the partition deed, it appears that I'm a co-sharer. A person cannot take two defense at a time. That is the ground for rejection of
mutually destructive.
Mutual destructive. That was the ground for my.
There is a judgment of the Supreme Court also against you.
But my point is that the question of adverse possession comes because the deed was executed, admitted by the plaintiff that I am in possession and I am in possession with the consent and knowledge of the original owner. And that is the reason they executed a partition deed. And this is
in order to succeed on the ground of the adverse possession, there are three basic legal the legal maxim: nec vi, nec clam, nec precario. These are the three basic principles on which the adverse possession lies. Have you been able to prove all these three ingredients?
First of all, admittedly, since 1984 to 2013, I am in possession with the knowledge and with the consent of the original owner. Admittedly, in 1992, accepting my possession and ownership.
Your position, the difficulty is that your initial entry in the property should be illegal. And then you can claim an adverse possession, and that too with the knowledge of the owner that you have trespassed into the property. And if it appears that there was a license which is given and the court and the owner has permitted you to reside in the property, then in that event, can you claim an adverse possession? You'll have to say when your possession becomes hostile, when it becomes the hostile to the whole world. You have to show that.
My humble submission,
say long possession in the property does not mean that you have acquired an adverse possession.
My humble submission, 1992 deed, the partition deed itself.
That is again, if you bank upon your adverse possession, then it is difficult, very difficult. You have to show when your possession becomes adverse to the plaintiff.
And the secondly, when the person, he himself admit me as a.
Yes.
When a person himself admit me as a co-sharer,
this is how the deed, where is that finding you show us?
Lordship.
Have you been able to show that deed, whether the deed was marked exhibit?
Yes, my lord, I can, my lord.
Then whether they have challenged that deed?
My lord, if your lordship kindly turn to, my lord, once my application for stay, I have annexed the plaint. Page 31 of my application for stay, my lord, I have annexed that plaint.
Page
31 of my application for stay.
Yes.
No, my lord.
Give us 2 minutes time. Let us hurriedly go through the plaint.
Relevant paragraph, paragraph 2, my lord.
Just one. Yes, what is your defense?
My defense lot find from the judgment of the trial court, which
No,
is
written statement you have filed.
yes,
That is
my lord, I have filed the written statement.
the 36.
Yes, my lord.
Yes.
Page 38 is the relevant portion.
Yes.
And my lord, the finding of the trial court, my lord, find from inner page 15 of the trial court judgment.
Yes.
Which, my lord, as I argued, my lord, that this is the court's finding is it's mutual destructive. On the one hand, I can my lord, ask for adverse possession, and at the same time, my lord, I'm asking for my lord, my right as a co-sharer. These are mutual destructive. This is the finding of
Internal page 15 of the no.
internal page 15 of the trial court judgment, my lord.
No,
In
not
this
15.
context, the court find it appropriate to mention that partition
Yes. So the court has said that the partition deed is not valid because you yourself disowned the partition deed in your suit, which was dismissed for default.
yes, my lord, that is on record.
So what can be done now?
Now, my lord, kindly appreciate, my lord, that the plaintiff himself admitted, my lord.
This is page 16. The draft. Just like protected. Yes.
No, my lord, kindly appreciate, my lord, that we are possessing the property for last 80 years. And my lord, at the same time, my lord, the plaintiff himself admitted, my lord, as a co-owner.
No, sir, that was not believed because you disowned that you are not a co-owner.
But that was a registered instrument, my lord. It's a registered instrument. And my
Whatever
lord,
instrument was not never acted upon because you have disputed the validity and authenticity in your suit, which was filed in 2000, sir.
that was dismissed for default, my lord.
Whatever, then your contention would remain.
But at the same time, my lord, it is a plaintiff's admission, my lord, plaintiff's case that there is an existence of partition deed, my lord.
But he says it was never acted upon, and from your plaint, it appears that you are also not agreeing on that particular deed of partition. You also said no, no deed of partition, not a valid one.
That is there, my lord.
Then what? Then what?
But my lord, kindly appreciate, my lord, that they have himself admitted our ownership, my lord, possession, my lord, as well as, my lord.
On that basis, position they have. For that, they want a eviction. But so far as the title, I have a doubts. When you yourself says no, your title does not pass on the basis of the partition deed.
And as well as, my lord, kindly, my lord, don't, my lord, throw, my lord, my plea of adverse possession also, my lord, because it
Now,
is.
I'm asking you the plea of adverse position, how you have proved that when your position becomes adverse. Tell us.
My lord, after the death of my father since 1980, my lord, we are in possession, and my lord, it become, my lord, it gets the same.
Then show me one judgment of the apex court that the long position tantamounts to an adverse position. I will accept because your contention is that you are in a long position.
My lord, not only the long possession, with the knowledge and consent of the, my lord, the owner.
I'm saying long position with the knowledge and consent of the owner. Show me one judgment that it tantamounts to an adverse position.
And my partition deed that also established.
Partition deed you yourself disowned.
But kindly, my lord, forget that part, my lord, for the time being. But it is the admitted position, my lord, that in the partition deed, they accept my ownership. They accept my possession. My ownership was accepted in the partition deed.
Sometimes the bad cases are not to be argued much.
My lord, I know, my lord, it's a eviction of licensee and, my lord, judgment of affirmation. But only because of this partition deed, I find something, my lord.
Frankly, the moment you said that partition deed, everything that came, we just started in reading the brief. Thereafter, after finding, we don't think so. That
There are something arguable, my lord. Kindly appreciate.
Yourself has done the mischiefs.
My lord, I'm in 80 years in possession, my lord.
Whatever. Sorry. A suit for recovery of possession against a licensee was decreed by the trial court, and such decree is affirmed by the First Appellate Court. Admittedly, the predecessor in interest of the defendant, appellant, executed a deed of sale in favor of the predecessor in interest of the plaintiff way back in the year 1944. The veracity of the said deed was the veracity of the said, the veracity and the genuinity of the said deed of sale executed in the 1944 were never challenged. They were never disputed by the vendors nor by the predecessors, by the successors. However, The fact, however, the position remained with the predecessor of the defendants, appellant, and subsequently with the defendants, It is a specific case of the plaintiff respondent that the predecessor was initially permitted to remain in occupation as a licensee, and after his death, the defendant appellant was permitted to remain as a licensee for a period of 5 years. But upon an expiration of the said period, the defendant appellant refused to vacate and hand over the possession of the suit property. And therefore, the plaintiff respondent is entitled to a decree for recovery of possession. A defense is taken. The multiple defenses taken by the defendants in the written statement, as well as the additional written statement filed before the trial. According to the defendant appellant, even after the execution of a deed of sale in the year 1944, the possession remained with the predecessor of the defendants. Now, with the defendants and or his predecessors uninterruptedly, which indicates that the deed of sale was a mere paper transaction and never acted upon. It is further submitted that they are occupying the premises for several decades, and therefore have acquired and therefore have perfected their title by way of adverse possession. Another defense which is taken on the basis of a deed of partition executed in the year 1990, and it is sought to be contended that by virtue thereof, a right in respect of the property was recognized by the plaintiff respondent, and therefore they are a co-sharer and not a licensee in respect of the property. Both the courts disbelieved the aforesaid stand of the defendant appellant. The trial court categorically observed that the defendant appellant filed a suit for partition, being title suit number 72 of 2000, again in respect of a self-same property against the plaintiff respondent, claiming to be a co-sharer on the strength of a partition deed. On the strength of a partition deed, claiming a co-sharer in respect thereof. It is further observed that in the said suit, the defendant appellant have taken a plea that the purported deed of partition executed and registered in the year 1990 is not a valid and authentic, and was never acted upon.
Partition deed of 1992.
92. 1990 jaga 1992. It further appears that the said deed of partition, the moment the defendant appellant have taken a stand that the purported deed of partition is not authentic and or valid. It cannot fall back to the stand that by virtue of a deed of partition, they have acquired the right, title, and interest in respect of the property. A person cannot be permitted to approbate and reprobate at the same time. Full stop. Furthermore, the partition and the separation of the share by executing a partition deed connotes a pre-existing rights of the parties thereto, and not a creation of a right for the first time in favor of a person. Both the courts have held that the predecessor of the present defendant appellant or divested their right, title, and interest in respect of the subject property by executing a sale deed in the year 1944, and therefore the defendants or its predecessor cannot claim a pre-existing right post 1944. So far as the plea of adverse possession is concerned, the court found that the plea of co-sharership in the property, co-sharership in the property, and the other adverse possession are mutually destructive and cannot be permitted to be taken by the appellate. Even if there is no dispute to the proposition in this regard that a person cannot blow hot and cold at the same time. Even if the plea of co-sharership is found untenable, let us proceed whether the plaintiff, the defendant appellant, have been able to make out a case for adverse possession. It is no doubt true that the possession is a 9th principle of title, on title, principles of title. The Limitation Act recognizes the possession having culminated into a title. After the expiry of a specified period. Stop. In order to succeed on a plea of adverse possession, 3 basic principles are required to be proved as indicated in a legal maxim, namely NEC nec VI, nec clam CLAM, nec precario. Meaning thereby the possession must be continuous, hostile, and adverse to the original owner. Stop. Mere long possession cannot ipso facto convert into an adverse possession. in order to, like, the person claiming an adverse position must prove with cogent evidence that such position is hostile, continuous, uninterrupted, and to the knowledge of the original owner. Stop. It would be preposterous to suggest that a long position tantamounts to an adverse position in absence of those principles having proved by the person taking plea thereunder. It is a specific case of the plaintiff that the defendant appellant was a permissive occupant, and both the courts have found that the defendant appellant has failed to make out either a case of co-sharership or of an adverse position, which we do not find, that it needs interference. There is no involvement of a substantial question of law in the instant appeal. The appeal is dismissed under the heading order 41 rule 11 of the Code of Civil Procedure.
Grateful, my lord.
Yes.
This is the matter relating to, my lord, or my submission is of twofold. One is of my defense from the very beginning is that of my predecessor interest was the right court for right holder.
Bhushan Chandra Biswas was the admitted owner.
Not the admitted owner, he was the Korfa occupier.
Korfa tenant.
Korfa tenant.
Say the Korfa tenant. Upon his death, his widow Narayani Devi, Narayani Dasi, and one daughter Sumati Noskar, they were there. Sumati Noskar gifted her share to Karthik.
And
yes,
the plaintiff got the property from that branch, from Sumati.
Karthik executed another gift deed in favor of Kaveri.
Yes.
Kaveri in turn sold it to the respondents.
The respondent, plaintiff respondent.
Now this Sumati had 5 heirs. One Bhola, another Karthik, another Radhanath, my 2 daughters Renuka and Shefali.
Yes.
You are claiming through Radhanath.
Through Radhanath, absolutely.
And
the point of law is very limited. The record, CS record of rights, where Corfa occupant is stated, it is already part of the my application. Kindly comes. It is at page 69 of my application.
do you have a Bengal Tenancy Act?
Bengal Tenancy Act, my lord. Bengal Tenancy. I borrowed it one of my seniors. The Bengal Tenancy Act, after there is no repealing provision regarding Bengal Tenancy Act subsequent.
But by virtue of,
of
the state
the
acquisition and the land reforms,
rights have
something
been
has been diluted.
taken care of.
And even a non-agricultural tenancy.
Absolutely, well, my lord. But my lord, the situation is kindly comes to page 69. Page 69 is the CS record of rights, where it says that Bhushan Chandra Biswas is the Korfa Dokoli Shatto Bishishto. So his right of possession as Korfa was under Sushil Moni Dashi. It was not.
What is the concept of Korfa?
The concept of it was given for a particular purpose.
What?
Like the Thika tenancy here in Kolkata. For a particular purpose, it is my understanding. I may be wrong, my lord will correct me. That is that particular purpose. It was given. Usually, it was given for a limited period, 5 years or 10 years. This right, for the record of right, it shows this right was under one Sushila Moni Dashi. So Sushila Moni Dashi was the intermediary. Here I am, my lord, raising the point. He was not a Korfa tenant under the state of West Bengal. So there was an intermediary. So because of the Estate Acquisition Act, his
right of intermediary goes.
Right of intermediary goes, and his right cannot be, my lord, cannot be established is that of a Rayati right, because he was a under tenant. He was not the direct, my lord, the Rayat who was in possession of the property. He was a under tenant. Under Sushila Moni, he was occupying. But that here I am, my lord, I have a point, my lord. So whatever right he had, he has a right of possession only, but under the state of West Bengal. It has not been, my lord, established is that of a Rayati right. If that be the position,
not been elevated to the state of the status of the Rayat.
Right, absolutely. If that be the position, my lord, the subsequent transfer by his legal heirs, who has a only right of possession, my lord, I am, my lord, supported, my lord, the judgment of this honorable court also, that right cannot be transferred.
Was there any embargo?
But the right of possession cannot be transferred because the right, my lord knows, unless I have a right of ownership.
Right to possess.
Right to possess, my lord, I am in possession, my lord, I
can. That what is the concept of a tenancy? The concept of a tenancy is that right to use and enjoy
right of possession
by
and to
way of
enjoy
a
the
possession
property
is given to a person, and thereafter in lieu of certain considerations, which may be called as a rent, which may be something else,
or in lieu of service also.
It is what is a really a right to transfer the use and enjoyment. What is the meaning of the word use and enjoyment? Does it mean the possession as well? Because what is the meaning of the word possession?
Had it been a lease, possession with some usufructory right.
Whatever, it's not a lease, let us see. It's an open
it's a
tenancy.
Pure tenancy. So if I take
open tenancy, where is the difficulty?
But if
open tenancy.
If Radhanath is in continuous possession of the property, but that possession cannot be disturbed by another person by way of subsequent transfer of possession. It cannot be done.
No, that you are. That to some extent you are. Correct. May have some
points, my lord, in that regard.
Based upon which?
But my right of possession.
Right, give that judgment of Khitan consultants. What is the judgment? Justice. Every judgment, justice. Khitan consultants, I believe. Khitan consultants judgment.
The Bengal tenancy, my lord, I have only one copy photocopy, my lord. I'll kindly consider it. Property.
Lost that right to be transferred to same right. School not same right.
At least before this transfer took place by my mother, that time I was in possession.
After the transfer, you were not in possession.
I am always in possession, my lord.
Let me also go through it because
Yes, my lord.
it's a very
Because
old
my lord, you also consider section 51C of the Estate Acquisition Act also.
I want to refresh and
May I read out, my lord, section 51C? My lord.
No, that is a different one.
No, my lord.
Right of an person appeal.
It's a non-legal tenant, but every non-legal tenant holding any land under an intermediary, here Sushila was the intermediary, until the chapter such and such, every 51C.
Yes, that is a 5 connotes the effect of notification.
Yes, that has came into effect subsequently. So every riot towards the middle, my lord, every riot holding any land under an intermediary shall hold the same directly under the state, as if the state had been intermediary and on the same terms and conditions as intermediary before the date of vesting. So his right of possession.
Question is again a corpa tenere. It's a different concept. That is what I am asking. I just wanted to
No, my lord, no, my lord.
Say that it is no right of intermediary vested.
So my right cannot be elevated to not to that of any right to transfer. That is my question. Yes. Yes, ma'am.
Is not to be.
Ma'am.
Yes, yes, call the next.
Yes.
I don't know whether the objective action. No. Paragraph 9. Lordship will kindly pardon me, I just collecting from Bar Association. Oh, only one. This is as far as
plaintiff in a suit for eviction of a lessee upon expiry of lease by efflux of time.
Yes.
Both courts.
Why?
On the simple ground that the plaintiff's power of attorney holder who instituted the suit did not produce the power of attorney.
Suit was instituted as a constituted attorney.
But in the name of the plaintiff,
Correct.
but signed by the constituted attorney.
Correct. Who are constituted attorneys? They could have asked to produce it.
I'm carrying judgments to that effect. 1996 and ILR Allahabad, full bench.
Then you forward them. The appeal is admitted on the following substantial question of law, whether both the courts below were justified in dismissing a suit for recovery of possession on the ground of expiry of lease by efflux of time, as the constituted attorney did not produce the power of attorney executed in his favor by the principal, comma, the plaintiff.
And there's one order
Anybody
4127. Yes.
Oh, record. Yes, can we fix the appeal without framing a substantial question of law? Can we decide it here and now? Tell us the date. We can fix the matter and then decide it. Anytime.
Last week of April.
Give me a date, particular date when you are ready. Then we are not admitting.
No, but admit it.
What admitted?
Admit it and then post this for
No,
single bench.
we can't.
Single bench.
Let us see. Tell us. Yes. That's the Thursday. No difficulty. After hearing the appellate, we feel that the justice would be observed if the appeal itself is, the second appeal itself is decided
Along with the current application.
on a pure question of law involved in the incident. The respondent have appeared in the instant appeal, and therefore there is no impediment on the part of the court to decide the main matter in their presence. By consent of the parties, let this matter be listed on 25th April 2024 to be taken up at the first sitting of the court. We make it clear that in order to dispense justice, as admission of an appeal would unnecessarily explode the docket of the court and shall not inure to the justice to be imparted to the parties, we have directed the matter to be listed not only for admission but also for final disposal. Yes, sir.
Grateful.
Come with the judgment of Justice Ramindran on this point. Come.
Grateful minute.
Yes.
There is a Miller defect in. Kindly give us an opportunity.
Patel one.
My lord.
Patel one, sir.
No, Miller. The name of the defendant, Miller, that has been missed. One of the defendants that has been missed out. Respondent. We need to incorporate his name and address.
Limitation has intervened. What is the date of the judgment of the appellate court?
Yes, Miller. 28.
2nd of September 2023.
Yes.
So, sir, limitation.
Huh? No. Certified copy, Miller. The date of opt-in application and opt-in, Miller. The stamp report and report, Miller. We have not checked it up.
If you want to add a left out party, then the question of limitation will also arise. If you do not implead a party who should be impleaded, then limitation. How to overcome with the limitation?
Yes, but if I add today, Milord, then Milord is 15th March. If I add Milord the name of the defendant that has been missed out, Milord, I say Milord the limitation will be over, Milord, in this month. March.
Limitation is going to over in this month. It is within the period
19th
of limitation.
19th March.
19th March, we have already crossed.
19th March is the date of limitation.
So we have crossed that. Then what to do, sir?
Sir, permit me to Milord file an application.
What?
Limitation means because the defendant, Milord, that is an unintentional omission, Milord. While Milord typing out, at the time of typing, Milord, this has been. There is a defect, Milord, not incurable, Milord.
Yes. It's a fatal defect.
Only
Should I
Milord,
give you a judgment of our High Court, which says that no, it's a fatal. If you do not implead a party
no,
who
Milord,
were
it
there
is-
in the
I
trial
tell your
court,
Lordship, Milord, the fact
then-
is, Milord, the bunch of defendants, Milord, while typing out, Milord, this escaped his notice, Milord. Kindly, Milord,
then what kind of a notice he gives to a matter?
I tender my apology.
What is the matter about?
Suit for declaration of title and possession, Milord, this has been.
Possession means recovery of possession or confirmation of
The
possession?
confirmation. And Milord, both the courts, Milord, went against my client.
You are a plaintiff. So you could not prove your title.
Yes, Milord, and the court relied on, Milord, the ROR, the record of rights, and the deed which I have produced, Milord. The ROR, Milord, got precedence over, Milord, the title deed.
Show us.
And Milord, this and the court had
Show us
also,
this portion.
no, Milord, the court had also said that the title deed, Milord, the appellate court, both the court, Milord, kindly, Milord, takes pain, Milord, to turn the judgment and decree dated.
No, just show us that portion that the court has said that the title deed does not have
If
anything over the
if
ROR.
that be the scenario that is to be considered,
Which
with
one?
that
Where?
Milord page, title appeal 07/2019, page number 9, page number 9.
Yes, show us.
If that be so, the last para, that is to be considered whether the sale deed bearing number such and such has
Where?
been able. Last
No,
para.
if that be the scenario, it says.
Yes.
It is to
Kindly
be
see, it is to
considered.
be considered whether that the sale deed, that is my sale deed, Milord, that was executed in favor of my predecessor interest, has been able to rebut the presumption as made out by the recording of the name of the defendants in LR and ROR, though the appellants have very vehemently stressed upon the presumption under section 90. But the learned trial court has very rightly observed that presumption is may presume option, which means it is not conclusive proof of the alleged documental contents thereof. Appellants plaintiff have also tried to rely heavily upon the ROR, which was exhibited as Exhibit 2 and KG Khotian, which was exhibited as Exhibit 3, but it is seen that his official witness from the ADSR office itself could not satisfy in his cross-examination as to unimpeachable sanctity of the recording. PW3, Bijan Kumar Sardar, authorized by the revenue officer who exhibited such and such RS and ROR, and said that the same is in the name of Upendra Maji, stated in cross-examination that in the name of said column 13, RS ROR 143,876 recorded in the name of Upendra Mondol, son of Mohan, and he expressed doubt stating that in respect of the plot number 389, it cannot be said whether the same is recorded in the name of Upendra Maji and Upendra Mondol. Again, 54th, Pinky Hussain Mondol, who exhibited KB Khotian 240, stated that plot number 389 having total area 11 decimal is recorded in the name of Upendra Maji, but in cross-examination he stated that the said Khotian is the name of 19 persons, including the name of the Upendra Maji. He stated that the name of Kinkar Mondol is also reflected in the said Khotian, and the plot number 389 is recorded in the name of Upendra, and admitted that no title of the said person is reflected from the said Khotian. He categorically admitted that from the instant Khotian it cannot be understood in the name of Upendra, plot number 389 is recorded. So what transfers from the evidence of PW34 is that RS and ROR in respect of plot number 389 in connection with Khotian number such and such and the KB Khotian number 240 has not been established beyond doubt or to the sufficient preponderance of probabilities to be in the name of Upendra Maji. Moreover, as has been pointed out by the respondent defendants, that there is no proof in respect of continuous and uninterrupted possession over the suit property by Haripada Maji or his legal heirs, that it is my client with 1958 till the present date. No witness has been adduced in favor of such possession. No khajna receipt has been produced pertaining to the period since 58 till date. And it is very surprising as to why absolutely no attempts were made either by the Horipada and or his legal heirs to get their names recorded in the land records. Not only that, there is there is also nothing on record regarding any complaint made in respect of wrong regarding alleged by them to have been made in the name of the defendants or any application for rectification of record of rights. Only khajna receipts were filed but were not marked as exhibits are in the name of Upendra Maji, who according to the plaintiff had transferred the property in the year 58. Respondent have contend that there are some witnesses cited in deed of 1958, namely Narayan Das, Jagannath Maji and Prabhat Das, and raises question as to why none of them were called as witnesses or any of them were that expired. Why no witness who may have been acquainted with their signature was called for to prove the same. Respondents bring to the notice of this court cross-examination of PW1, wherein he has stated he can call witness and prove his possession since 58, but no such witness is adduced. He also mentioned in cross-examination that he did not submit any document in support of his possession. On the other hand, defendants have produced RSROR in the name of their predecessor Kinkor Mondal, have also produced PW2, Tapan Mondal, who deposed in favor of their possession. Another very relevant point raised by the respondent is that proper boundary has not been mentioned in the deed of 1958, and the same has been admitted by the PW1 in his cross-examination done on 11/10/2017. Respondents also raised the point, since the appellants have failed to prove continuous possession since 58 and have not made any prayer for recovery of possession, the suit is barred by the provision of 34 of the Specific Relief Act. And in support of his contention, they have referred to the case of Sachin Ghosh versus Niranjan Chandra Ghosh, referred to above, wherein it has been held that the record of rights indicates prima facie possession, and without correction of record of rights, prayer for permanent injunction in matter of possession cannot be granted. In this case, as contended by the respondents, since plaintiff has failed to show his continuous possession over the suit for declaration filed by him, along with the prayer for without praying for recovery, is barred by provision. So, considering the totality of the fact, circumstances, legal position made out, the court is of considered view that in absence of any supporting document in favor of or to substantiate the deed of 5853 of 1958, the same or contents of the same cannot be concluded to be proved. On the other hand, basing upon the observation made by the Honorable Calcutta High Court, Amulya Ratan Ghorai versus Secretary, it is established that when there are two record of rights, the latter shall prevail, and it is for the opposite party who challenges the correctness of the record of rights who has the obligation to rebut such presumption, and on his failure to rebut by adequate evidence, the entry and record of right has to be given effect in favor of the person in whose name such record stands.
The appeal shall be heard on the following substantial question of law, whether the entry in the record of right has overriding effect on the deed of title merely on the score that there was no receipt produced by the plaintiff after the purchase of the property with regard to payment of the land revenue. Next, whether the presumption of due execution raised under section 90 of the Evidence Act has been sufficiently rebutted by the defendant respondent solely on the ground that the witness to the said deed were not brought to the court to prove that the possession was given to the plaintiff appellant. Expedite the suit. File the requisites within a week.
Yes, sir.
Milord, we have
Service. Oh,
Milord.
you have filed a application.
Yes, Milord. They have Milord.
Serve the copy and go before the regular bench.
Milord, in the meantime, kindly give us.
No, whether you were enjoying any interim order during the pendency.
No.
Then service after 2 weeks. Put a the regular order. Single bench court. Yes, next.
Deeply obliged.
APA for, excuse me.
Yes. 21.
Appellate. Yes, Lordship. I'm led by Mr. Siddhartha Banerjee in this matter, my lord.
SAT or FMET?
FMET, Lordship.
FMET.
And it looks to my lord's last order, my lord. I don't know, my lord, whether the other appeals have been filed or
Yes, it has been.
My lord, my learned friend took a technical objection on the last occasion that was from the extension orders. My lord, we have not filed any appeal. Those appeal, my lord, have been filed. May my lord supply the numbers so that my lord, they can appear together. My lord, any day that is fine.
Please.
stay fine first.
What is the matter about?
My lord, this is my lord from an expert identity model of injunction in a suit, my lord, against my lord, the SURFACE action.
But those appeals are not.
You have no right.
Those appeals have not come up.
Which one?
The later ones which have been, my lord.
But that will ওটাকে supplementary list এক্ষুনি করে দাও 5 মিনিটের মধ্যে। We treat it as on days. Don't worry.
I have not looked into it. That's why I said. Otherwise, I don't have it.
Come tomorrow. First matter.
Maybe day after. But I am giving
You
him
will
time.
be difficulty. You will be in difficulty. You do not know.
No, my lord, it's still 9th. It's okay. It's fine.
Again, the second extension will come and the same period.
It's still 9th. He knows. That's why.
On 9. Before the net code will it's returnable on
Day after. Hey, give the number.
Yes,
Yes,
I will
Let this appeal be listed along with. Give that number.
I'll immediately
On Wednesday.
So grateful to your lordship.
তুমি এসেছো আর কৃষ্ণ এসে গেছে ইসকন এসে গেছে
Yes.
Please also. But the plaintiff in title suit number 160 of 2003 is the Milord appellant before your lordship in a suit for declaration of title. Milord, the appeal is directed against Milord a judgment of reversal. Milord, 4 dates are very important. Milord, our vendors are the same. The date of execution, Milord, of the appellant of the Milord, the property or the deed is 9th of December 2002. The date of registration of my deed, Milord, is 24th of April 2003. My learned senior friend's date of execution, Milord, is 12th of March 2003. That is later than, Milord, my deed. And the date of registration, Milord, is 23rd of April 2003. The court has held, the appellate court has held that my execution may have been fraudulent.
and my lord reverse the degree, my lord, on that ground. Not looking into the fact there are 2 points. Section 47 of the Registration Act and my lord, the fact that he is
That it will relate back to the date of the
Yes.
execution.
Yes.
But now let us see from the date of an execution, the registration has to be done within what period?
it was done in